Welcome, everybody. I think we're going to start with, as usual, our staff report. So, Andrew?
Attendance first.
Oh, attendance, yes.
Okay.
Amy.
Roll call.
Amy Bomsey,
Here.
Stephen Bundy,
Here.
Kendra Basner, David Carr,
Here.
Eric Deitz, Andrew Dilworth,
Here.
Justin Fields, Matt Hodell,
Here.
Toby Inlander, Adam Koss,
Here.
Amber Lee, Dina Roche, Teresa Schmid, Richard Solomon, Stephen Sparta, Marsha Whitney. Thank you.
And actually, I forgot that next we have to ask if there's anyone here from the public who wants to offer any comments. Okay. Hearing no public comment. I don't think we have any announcements other than we have the symposium tomorrow, but I assume everyone knows that. Anything else to announce? No, I think we can do the staff report.
Okay, great. Good morning, everybody. As Amy just alluded to, this is our yearly meeting before the symposium, so I just like to thank everybody, the moderators and panelists. I know it takes a lot of time and effort to put these panel presentations together. It's all on a volunteer basis. The programs, we've been reviewing the materials as they come in, are always at a very high level, and so just speaking for myself personally as a staff person, just really want to thank everybody for the effort and energy that goes in to this really great program. So thank you all for that. For those who, as a housekeeping item, for those who are staying overnight in conjunction with your symposium panel presentation tomorrow, there is, staff has a tax exempt form because you're on government status. You'll need to present that to the hotel in order to receive the benefit of not paying certain local taxes. So please be sure to pick up that letter from either myself or Mimi before you leave today. And that's it with respect to the symposium. Transferring to the work of this committee, we have two opinions that are currently out for public comment. 120003, which is the attorney rating website that has a deadline of May the 14th. 13003, which is the ethical obligations when departing a law firm, is out for public comment, and that has a deadline of June the 17th. As of today, I don't think we've received any public comment on either of those opinions as of yet. 14004, which is the witness perjury opinion, its deadline was February 27th. So that opinion is on today's agenda, along with all the public comment letters we received with respect to that opinion. The Board of Trustees met on March the 14th, and I'm pleased to report that they approved the size of COPRAC going forward to be a size of 12. You may recall all committees and commissions of the board have been undergoing a review process as part of the Governance and Public Interest Task Force mission that's statutorily stated that the board must do every 3 years. There were a handful of committees and commissions which fell under what colloquially became known as Appendix I. Those were committees and commissions with whom needed further discussion as to whether or not they should change or remain. If you'll recall, COPRAC did not fall into Appendix I. Initially, they were determined to be an important regulatory function of the bar, and so they were retained. That was a decision that was made fairly early on in the process. However, now they've come to a conclusion of reviewing all committees and commissions. That review resulted in some global recommendations for committees and commissions, such as the default size of all committees and commissions should be 7 unless a compelling reason could be stated otherwise. So I would just like to thank David Carr for taking the lead responsibility for initially drafting that letter. I know our chair, Amy Bomsey, provided further edits and clarification to that letter. I can't speak on behalf of the board or the executive staff, but it's just my impression that the letter was very well received. And so I think you guys should be proud and pleased that the committee will be a size of 12 going forward. Unfortunately, it's not all good news. One of the recommendations for all committees and commissions is that they no longer retain an advisor. So after this year, we'll no longer have an advisor position on the committee. For those of you who are already appointed to the committee, do not fear. Your 3-year term will proceed in due course. It does not affect anyone's participation in the committee who's already a member of the committee. We will be appointing new members this summer to take position on the committee in the fall, and those committee terms will now be transitioning to a 4-year term. Previously, they've all been 3-year terms. One of the recommendations for all committees and commissions is that the appointment term be that of 4 years, so that'll be a change. There'll be a transition period over the next couple of years as we get the 3-year people cycled off and the 4-year people on for their continual basis. But that's something for staff to worry about, not really things for you guys to worry about. However, with respect to the appointment process, you'll recall this committee usually put together a appointment subcommittee, and the committee itself would review applications and make recommendations. One of the global reviews for all committees and commissions was to have to not have the committees themselves make appointments for membership on their own committees. There has not been a determination as of yet as to what the appointment process will be. It's under consideration, but we'll certainly let you know once a determination is made. Along those same lines, we used to elect our own vice chair. We would take a vote amongst ourselves. Again, no determination with respect to that process has been made, but I think it's fair to assume we probably won't engage in that process again. So just keep your eye out for an email from myself, most likely, requesting any second or third year members either interest in being nominated as the vice chair, or a declination in interest, meaning like, I really enjoyed my service here on the committee, but if someone else were to point me out to be a suitable member as vice chair, I don't have the time, interest, or ability to do it, so please don't consider me as a potential applicant for the vice chair position. I don't know whether either of those approaches will be the approach we ultimately settle upon, but that's a reasonable possibility, and I just wanted you guys to be aware of that. And I can take any questions. Let me just get through these last 2 items. I'm sure there might be some questions based on what I've shared. The last 2 items are the Access Through Innovation and Legal Services Task Force met on Monday. Amy and I were at that meeting in San Francisco, and their next meeting is May the 13th. And they are on course to get a report and recommendation out for public comment sometime over the summer. So keep your eye out on that, and I'm sure when the report and recommendation goes out for public comment, there will be interest from the thoughts and views on that report from this group. So again, just be aware that that might be coming, and of course staff will keep you informed of that. Yes, Teresa. Good question. I think it's here in Los Angeles. I don't have the meeting on Monday was in San Francisco, so my gut reaction is probably in Los Angeles. I can confirm that and let you know. And then lastly, the Assembly Bill 1987 assignment that was sent to the State Bar, as I reported last meeting, regarding studying whether the rules of professional conduct are sufficiently clear as to an attorney's responsibilities with respect to retaining a criminal client's file for post-conviction discovery purposes. If the rules are sufficiently clear, we are been tasked to study and make a recommendation as to whether or not the rules are sufficiently clear, and if not, what changes might be made to make those duties more clear for an attorney. That is in your agenda packet today, and hopefully we'll be able to get a chance to discuss that so we can be responsive to the legislature with respect to that inquiry. And once again, I've said more than I need to say, and so I am done unless there are any questions. Okay, thank you. Yes, so the question was if we know how many people will be appointed to the committee next year. And so the assignment to go down from our current size of 16 to 12 is to do that through attrition, so allow those people who naturally cycle off to cycle off. However, you still need to add folks every year, otherwise that would create problems down the line, which I know we all can see and appreciate. And so staff has worked out a model in order to get down to the size of 12 in just, a few years. And if that, so it hasn't been determined yet, but one way to do that, and I think a clear and helpful way to do that, is if we appoint 3 new members next year. So we'll see if that's ultimately the recommendation that is agreed to, but that's a recommendation I'm going to be making. Correct. Sure. So I'm only repeating the question because I think your microphone's off. So the question is, because we're assuming the role of drafting arbitration advisories, the board recommendation was to have 2 folks on this committee have experience in fee arbitration background. And Amy points out that David Carr, who's already a member of our committee, has a fee arbitration background, and might he count as one of those persons? And I assume that would be a possibility. Nothing would foreclose that. However, if we had an applicant who had sufficient experience in fee arbitration, if we had 2 applicants who had sufficient experience in fee arbitration, I imagine it would probably be most prudent to appoint those 2 people to keep them together. That being said, if we only had 1 or none, then yes, certainly the possibility of relying on David's experience would be available.
Okay. I mean, I guess I understand that we may not be any longer the ones making these decisions.
Right.
But I'm just expressing the view that hopefully, even if we did have 2 members who checked that box, if we had other applicants who were stronger on ethics,
Right.
It might, for the health of the committee, it might be useful if there was that flexibility.
Absolutely. I see the point you're making, and I think there's no reason why a quote-unquote totality of the circumstances approach in viewing each and every applicant would not be applied. I do take your point. I don't anticipate it's just a blind, regardless of any other background or characteristic. And said another way, I think the folks that have arbitration experience and ethics experience are going to be, stronger candidates than one who just has one or the other. But I take your point, and I don't think, just speaking for myself, I don't think you have anything to be. I wouldn't be. It depends on the applicant pool in any given year, but I don't think you need to be too concerned about the way you framed the concern.
And Andrew, just to be clear, the uncertainty about the appointment process applies now. Is that correct? To the new group that's going to be coming in?
Correct. So this is the first year where we're transitioning to a new appointment process.
Right.
So in years past, we've had the process where a subcommittee of this group would review the applications and
Sure.
make recommendations. This is the first year that is not going to be the process. So we need to work out a way as to what the new process will be.
Sure.
And that's still under consideration, not determined yet.
Okay.
But I think the global recommendations for all committees and commissions has been that it should not, those appointment recommendations should not be made by the committee itself.
Well, hopefully, I'll just make a pitch that if they want to involve the committee in some fashion without a definitive, say-so, I'm sure leadership and others will be happy to participate. And
I agree, and I think I'm. Oh, my microphone went off, sorry. I don't think staff is prohibited from sharing the list of names of applicants we've received, and we can share that list amongst the members, and if anyone has personal experience with those folks, positive or negatively, you can share those with me and myself individually, and that could help inform us. That doesn't, I don't see why that would be a problem.
Okay, so I think next we need to do the approval of the action summary.
There's one typo, I think, on it.
Okay,
It's the item A5 says 2018 instead of 2019, right? But with that, that's the only amendment that I noticed.
okay. Is there a motion to approve the action summary
As amended.
as amended? Thank you.
Thank you. Can we just substitute the roll call? Unless anyone's gonna abstain? No? Okay,
Great.
I just substitute the roll call.
Fabulous. Okay. All right, so now we can start discussing the draft opinions, and I thought we could start with the witness perjury, the revisions that Matt and Steve made to that based on the public comments. And maybe actually, Matt, you want to just say something about what generally a summary of what kind of comments we got?
Yeah, we received some from about 3 or 4 individuals and from 2 bar association committees. The Orange County Bar and was it the LA Bar or the San Francisco Bar? The San Francisco Bar. And you can look at those, the ones that synonyms would have been stout, so yeah, I guess we should do that. Stout advocacy, and then there were some other things that I rejected, but if you want to talk about them, we can. But in the interest of time, to get even the main event, you'll see in the red line, which I'm going to work off. There were 2 things that I want to call out. There's only one thing I want to call out, which is near the end. There's a lot of redrafting dealing with something that I decided after going to the Orange County Committee, which I'm after I've listened to them, and not attempting to do anything like again in a meeting where I wasn't present, which is that there are 3 former COPRAC members on the committee, all of whom I respect. And they thought, as a group, the problem with scenario 3 is that you were compelling a lawyer to withdraw in a scenario where it probably would be ethical for the lawyer to remain in the reasonable argument. Remember that scenario prior version. That was where the client and lawyer learned that the witness had perjured himself or herself. Lawyer wants to strike the testimony, client says no, and that we just left the facts with that. So the client's not. That's. I think some people justifiably, and I agree with them, under those circumstances, because you're never gonna refer to legal counsel, you are not going to seek the benefits from it. Okay, that you can go forward, because that will not, we'll talk about this, and we'll look at the mandatory withdrawal provision and study this 30th time. There's a difference between will, where you're, I have it on red. So it says where you have a mandatory duty to withdraw where the continued revocation of provisions will result in violation. That's mandatory. And when it's likely to result in a violation, it's been far after, then you are admitted to the permissive duty to withdraw. So it seems the best argument to make in scenario 3 was that it's just a permissive situation and that you can make. So
Sorry, I apologize. That was a lot louder.
Should I start over? Yeah. So I thought this was important, and what I decided to do was to redraft scenario 3 to make it even more vivid, to show that there in fact is possibly a conflict between the lawyer and the client, discuss how to deal with that, and also to, rather than advocate or opine that withdrawal is mandatory, identified that the things that a lawyer ought to consider in deciding whether withdrawal would be mandatory or permissive. And I came up with a list of questions that I'm interested in getting feedback on, because I don't think under these facts we can always decide that there's a bright line in scenario 3 as it's redrafted, which again is the lawyer becomes aware after the lawyer has used the perjured testimony that it's perjured. The client, under the facts, the client didn't know apparently that it was perjured until the same time as the lawyer did. But the way I made these facts more vivid is the lawyer says, the client says, I don't want you to strike it. The client actually says, I want you to use the testimony. This is scenario 3, the way I've redrafted it. Of course, the lawyer can't do that. We make that clear. So the lawyer is going to go, has a choice. Can I go forward, try the rest of the case, go to oral argument, as long as I don't refer to it? And I don't think anyone can lay down a bright line. And so what I attempted to do was draft a list of questions that should go through the lawyer's mind. Not an all-inclusive list, we make that clear. And then at the end of that, I said that a reasonable lawyer, I put down the test that comes out of the rules, which is, would a reasonable, competent attorney under these facts know that there will be no is a term that is informed by which is also a defined term under our rules. So I have footnotes to that I fleshed out a bit. Does that lawyer have to withdraw? And I say, well, it all depends upon the factors that you evaluate. So that's what I attempted to do. So if you have the red line, I think the blue are Steve Bundy's changes, proposed changes, or at least the point we thought we just discussed them, and then Mimi's so efficient, she sent this out. But that's fine. That's what we're here. That's what we're here for. So unless anyone has any questions about what I said at the top, I'd like to walk through it.
Just, sorry, I don't want to jump in front of everyone, just for understanding as we continue with this discussion, do you disagree with Steve's additions or edits? Because if so, then that's something we can tackle later. I'm just curious about that as I review this red line, if that might be a separate conversation we should have.
I wouldn't say I disagree.
Right,
I think
would you have modifications to him?
I think they compound. This actually, if we could play the tape back and all the times we've discussed this. At one time we might have been saying false testimony, and I think someone correctly said, well, all factually incorrect testimony can be argued to be false. And that doesn't mean that it's necessarily perjured. I know falsity has a connotation that it's a lie. But perjury, in fact, is not just, if you will, if I accept that false means intentionally, intentionally, that it's a lie. It has to be material too. And so in the prior draft, we defined perjury, and we tried to use the word perjured as many times as possible, and versus a more encompassing term, which is falsity. Perjury has a legal technical definition. It must be material. So not all lies are perjury. Immaterial lies are not perjury. And those definitions are in here. So I thought that, and Stephen, you're trying to respond to, I think, one of the letters that came in where someone had written about that. So I prefer the way it was originally drafted. I can live with the way that you've done it because I think people, when they read, although there is one that I want to point out that I thought was, and unless do you want to comment on? Yes.
Before we do this, I think maybe we could take these two issues separately, and maybe we could first
Talk about the fundamental change?
talk about the issue of
Okay.
the more detailed analysis of when an attorney does and doesn't have to
Right.
withdraw in the scenario 3.
That would then start, if you look at the red line,
I apologize for not putting line numbers.
What page, Tim?
go to page 8, the first change to the facts I made. It's a remonstration has failed, can't strike the testimony, instructs the attorney to continue to use the perjured testimony. I agree with anyone. That's a bad client. That's a bad person. Okay, that doesn't mean you are required to withdraw under the rules. So then at the top of page 9, make it clear you're definitely in the area of permissive withdrawal. And rather than repeat all the rules, I said go read footnote 10 where the rules are there. Then we begin the analysis of whether the duty's mandatory. And the heart of it starts at the middle of page 9 with the red line where we talk about the comment to rule 3.3. And first I dealt with what 3.38 says. It says, there's a duty to withdraw that's pertinent here. If there's a deterioration, you have to read the first full paragraph above to see what I was referring to, comment 8, which was interesting. You have to break comment 8 into 2 parts. There's been a deterioration of the lawyer-client relationship such that lawyer can no longer competently represent and be diligent, or where continued employment will result in the violation of those rules. So it's a two-pronged analysis, two-pronged. So the first one is, you have a deteriorating client relationship. You can't agree on something fundamental. I get that. But it is true that standing alone, as I say, as I wrote, withdrawal, a substantial disagreement does not require an attorney to seek to withdraw. And I've always wondered, what does it mean when it deteriorates to such an extent you can no longer competently represent the client? I called Andrew Tuft and asked him what he thought. Sort of put words in his mouth. He said, well, that's where I'm not going to attribute this entirely to you.
I'll make this good.
Well, I thought it was good because I had trouble understanding what it was. Clearly, it's where the client impedes your instructions on everything that matters, and you can't even control the case any longer. You cannot be an effective lawyer because they're blocking everything that you want to do, or everything that matters. And so here you disagree on one thing. Client wants you to use it. Well, I'm not going to use it. I'm not going to mention it again. Okay, that box is checked. Is that in and of itself a substantial disagreement such that you must withdraw? And I don't think we can say that. In footnote 17, I tried to explain the possibility that it could cross the line, but it hasn't necessarily happened under these facts. I know somebody, one of the bar associates, that they wanted me to explain. Well, explain more. We could keep making this thing longer all the time, and I don't want to do that. So I did what I did in paragraph 17. And the last line is what Andrew said, and I agree with it. It's the problem where you are so disgusted with your client that you don't trust yourself to give it your all. You don't trust yourself to be diligent any longer. You don't care whether they lose or win, such that begins to influence your willingness to be a vigorous advocate, okay? So that's how I dealt with the first prong, but that doesn't get you out of the woods. The second prong is at the bottom. Never referring or relying upon the testimony again will be insufficient, according to comment 8, if continued employment will cause attorney to violate the rules. And then I discussed the difference between will and was only likely, and there's really no elucidation of that I could find in the rules of professional conduct. They say that, so now we're at page 10, the difference between will and likely is not always clear, which seems to be an unassailable truth. And then I began from there, the next 2 paragraphs are discussing the questions. First, I just put down the dilemma, which is you've already used it. It's already embedded in the case. The opening statement, you used it. You may have asked your own client about it. You've cross-examined other witnesses about it, I'm sure. It's there. It's not going away. But going forward, you aren't going to use it again. You aren't going to refer to it. I don't think that's always your way out. You have to do a deeper evaluation, which is the paragraph that begins, on the other hand. And what did I mean when I wrote I mean, are you going to make other arguments in that case that are underpinned in some way by the testimony from the perjurer? Do you have expert witnesses who have formed opinions in this case that are relying upon the perjurer testimony? Did other witnesses rely upon it? Have you achieved rulings in the case from the judge that assume that accept that, and so you defeated motions in limine, which continued to benefit you through the trial? Worse, when the other side moves for non-suit, will the judge, and I've seen, how judges can be vigorous advocates. A judge might say, well, I already heard this witness say the following, so I'm going to deny the non-suit based on that. That just deepens your dilemma. To offer some examples of where you could be put in a position where no matter what you do, no matter which direction you turn, you can't sanitize your advocacy in the remainder of the case. And I don't know how to map it out, but I definitely think there are circumstances where a lawyer could be presented with that dilemma. But then at the end, we get to the conclusion. At the bottom of page 10, the analysis of these and other factors may lead attorney to conclude, remaining on the case will constitute implied consent or endorsement. And there's our old footnote 19. There's our old, this opinion's opinion from 1983. Just flawed in some ways and fine in others, but I took the best soundbite from it, the one that I think is acceptable, put that in the footnote, and then at the end on page 11, if an attorney of reasonable prudence and competence would reach such a conclusion, then attorney's mandatory duty to seek to withdraw from the representation will have been triggered. And so that was the way that I solved the dilemma by, if you remember the lady or the tiger, that's my lady or the tiger.
Okay, so thank you, Matt. That was great. Maybe I'm just going to open it up for people to give their response to what Matt's done here in this section. Marshall.
It's a little off topic, but just before your conclusion, you talk about the consequences of filing a motion to disqualify and then it's denied.
What?
Yeah, it says if the decision is to withdraw, warn the client, move to withdraw, what happens if the motion is denied?
We have an opinion on that.
Right.
That is pertinent. Do we cite that?
And I note that we, on occasion, do question earlier opinions, so I have this question. When I read that, I thought, because I've had this happen in a case, it seems to give the lawyer somewhat protection from proceeding using that information. And it seems a little bit philosophically difficult to accept when you're not permitted to tell the court precisely why you're moving to withdraw, yet you give some vague explanation that I'm moving to withdraw because there's a breakdown in the attorney-client relationship, there's information I'm not allowed to tell you, Your Honor, but it's really fundamental, and I think under Rule 3.3 I have to get out. The court says, sorry, you're in the middle of trial, proceed. Does that give the lawyer the ability to now say, okay, I'm going to use this perjured testimony in my closing argument?
No, the lawyer clearly cannot use the testimony. That's not an authorization to continue to violate go ahead and violate the rules.
So now the attorney's trying a case with the direction of the client to use perjured testimony, and he doesn't, or she doesn't. I'm thinking now like the malpractice lawyer. That is a real Hobson's choice for the lawyer at this point.
Why would that be?
I don't.
Why would that be a difficult choice?
Wouldn't.
First of all, I don't know how it could be possibly. No client has a right to make you violate the rules. No client has a right to make you continue to use and rely upon perjured testimony. That would so you are breaching no legal duty to the client in conforming to your own duties there.
Well, I agree with that, but that doesn't necessarily get the lawyer out of the lawsuit because he or she's dealing with a client that's clearly amoral.
Granted, another element of this, Marshall, is you want to make sure you have documented that there was perjury.
Yeah.
Because the client, what really is you are suggesting is the client later on is going to say, I never heard that. We never had that conversation. And there'll be a factual dispute about what the lawyer knew. So you're talking about protecting yourself from a malpractice suit. I don't.
Maybe I can't get out of looking at that aspect of it, but it seems like at that point when the motion's denied, the lawyer's definitely got a real risk of getting sued.
Right.
Okay, so Dina had a comment on that, I think, and then I actually want to get back to the central focus of this, which is this consideration of when a lawyer does and does not need to withdraw once they know there's been perjured testimony. But Dina.
Well, my comment really, I don't think there's really that risk for the reason that you discussed, Matt. I mean, I think it's going to be documented, and I think the claim itself, I mean, you're trying to get cover from the court saying you can't do that. You brought a motion, it's been denied. I think that's sort of, you're in the best case scenario to move forward. If you had to move forward and you wouldn't be able to rely on the testimony, I think that's pretty clear. I really like this further analysis and further description of it because I think it's very complicated and nuanced. And I think the thing that I was struggling with was this concept that we're saying one of the remedial measures that can be taken is this idea of moving to strike the testimony. And if your client says you can't do that and won't allow you to do that, then there's still this situation in which you can move forward potentially if you decide that you can move forward and not rely on the testimony and not refer to it. And the thing that's kind of nuanced about that issue is if that's really the way that you've analyzed this, then you wouldn't, there comes a situation with your client where you would not necessarily encourage them to go forward and move to strike the testimony, because there's a way that would be less prejudicial to them if you moved forward in a way that was silent, right? If you move forward in a way that didn't rely on the testimony. And so I think, I'm just kind of, the analysis that I'm thinking about is, if you're trying to be this ethical person who's saying, like, this is one of my options is to tell you to move to strike, then do you also need to say to the client, but if you told me that you won't authorize me to do that because you won't let me disclose this information, then my only other option is to move forward and not rely on the testimony and continue on with the representation because we're in the middle of trial, which would clearly, in my view, be less prejudicial to the client. And so I'm not saying that I have the answer to how to work that out, but to me, it kind of strikes me as I look through this, and that was one of the problems I had with the Orange County comments, was just that they were saying, well, can't you just continue the representation anyway? And I do think that there's potentially situations in which you could, which is why I think I like the way you laid this out and dealt with these nuances, because it is complicated. But then I kind of thought, well, then no attorney is ever going to be encouraged to advise their clients to strike the testimony, because that is more, in my view, more prejudicial. So that's just something that occurred to me as I was thinking about that issue.
Are you saying that this should be clearer, that one thing you should do is, after you remonstrate, or part of the remonstration with the client, is say, we need to strike the testimony and you need to authorize me to do that, or I'm going to do that, and you hope they don't say no. You just go, okay, I'm going to strike the testimony. That's what we do when there's perjury. Okay, client nods, so you go strike the testimony. Is that what
Well, I think when you have a situation where we've seemed to say that there was one option, which is to strike the testimony, and the other option is that you could continue to move forward without referring to it. Okay, if we're saying,
I think both. I thought 3 was clear, that the attorney goes through it. This is perjured. First discussion with the client is, we got to strike the testimony. Client says no. Okay, next step. Client, you do this evaluation of the nuances. You decide whether you can go forward. First, you tell the client, I'm never going to refer to it again, despite your instruction to the contrary. And you evaluate whether you can do that, whether you'll be guilty of this implied endorsement that we discussed. So the steps would be, as part of the discussion, move to strike. You'll let me do that, right? No, you won't. I'm definitely not going to refer to it again, no matter what you tell me. And so I can't. I can never benefit from it again. And that's if you've decided you can continue to go forward with those criteria continuing to grip you throughout, or restrict you, or guide you, whatever you want to say, through the rest of the trial.
Yeah, I mean, I just wonder if the step is like, you ask them to move to strike, and then if they refuse to and insist that you rely on it, if we said you had to withdraw but the court denied that, then you can move forward and not refer to it. I guess what I'm saying is that I think that the options from the client's perspective, if you asked them to move to strike and they said no, and you just weren't going to refer to it, I think that not referring to it is less prejudicial to the client's case. Therefore, if they knew they had those options, in other words, if you said, if you refuse to let me move to strike the testimony, then under these circumstances, I suppose I can still go forward with the representation, but I just can't refer to it, that they'd say, well, I'll take option B. And is that what we want to happen in that situation? And so I don't know if what I'm saying makes sense, and maybe someone else has other thoughts.
I think it makes a huge amount of sense. I think it's super interesting. But I guess I think what Matt has done with his addition is to say what the lawyer needs to think about is, okay, the best choice is strike the testimony. The client says, no, I refuse. Then the lawyer thinks, if I just don't refer to it, is that going to be enough? And has to think about what Matt said. Did I win a motion in limine, blah, blah, blah. If he concludes that not referring to it is insufficient, then the only option he's presenting the client is, I move to strike, or I seek to withdraw. Now, so the client isn't given the option, or I could stay in the case and I would not refer to it. The client, so if the client chooses, the client's only choice is move to strike or I'm going to seek to withdraw. So the client could gamble that the court will deny that. But I don't think the client gets, I think what you're imagining, Dino, which would definitely be the client's preference over striking, is not the option that's presented to the client. Unless the lawyer concludes that not referring to the testimony is adequate to cleanse the record, which almost never will be the case, I agree.
Yeah, I just want to make sure that we're not, kind of creating that situation where there's a suggestion, well, that these are equal options that you have, and therefore I think most people would say, not that you would necessarily present it your client that way, but you would, have to look at both of those issues and say, these are equal options that I have, and so this is less prejudicial, and I'm going to go forward in this way. And I do think, it is obviously complicated. I think it almost would never, like you said, work out in a way that not referring to, depending on how far along you are in the trial course, but there's so many things, as you referenced, that refer to the testimony and people relying on it, and so many issues that make it more complicated. But so overall, I just wanted to raise that issue because it kind of occurred to me, as I don't want to be suggesting that attorneys kind of have that option at the outset to make that choice, because obviously it's an important issue, and I like your analysis and the changes, Matt. I think you did a nice job.
In your scenario, you're assuming a client profile of someone who reads COPRAC opinions, and so they have you set up.
No, she's imagining that the lawyer says, okay, I got to move to strike this
Right.
testimony. If you don't let me, I'll just not be able to refer to it. And the client, yeah, that's fine.
No, I just don't think it's ever that. Yeah, I've tried to head this opinion. I think heads that off. It says you. I mean, I was thinking about it more. If this is a key witness whose claim to have seen or witnessed the sexual harassment could have been repeated in demand letters that are in evidence, in emails that are in evidence. Again, you expert testimony could be relying upon it. So the lawyer sits there and goes, well, I'm going to use those demand letters for other purposes, but I'm never going to ask anyone to look at that particular paragraph. And I go, maybe not. We aren't going to tell you. You've got to figure that out.
But the other issue in this fact pattern, I think it's deliberate, is the fact that this witness is perjured themselves by, or has testified falsely about material facts, but it doesn't mean the underlying merits of the case are not true, and that may have actually happened to that person. It's just that this friend didn't actually witness that, correct? I mean, that's what we're...
Right.
So...
Although we do say that if you get rid of that witness's testimony, that the case, what do we say, likely will be lost?
It's a crucial witness.
Yes.
Right.
Yeah.
So, I mean, I didn't read this as saying the client is given that choice. I read it as saying, here's what the lawyer has to think about. If they're not going to be able to strike it, they have to make a decision for him or herself about whether or not they can move forward or whether it is mandatory withdrawal. And these are the types of things they think about. And I think it is context dependent, which is what Matt has done. He said you got to consider all these different things. And I think that's probably right, but I also think a lot of times the answer is, depending on those facts, maybe I can't move forward and simply not refer to things.
Or I wonder if, I mean, our old opinion, the whole like, go forward but don't refer to it again. I mean, maybe, I'm not suggesting necessarily we do anything different in this opinion, but it's worth thinking about whether, I mean, that's such a simplistic thing to say. I mean, is it more than just you can't refer to it in your closing argument? Can you not say anything in praise of that witness, like, about other testimony that wasn't false? I mean, and I think you're raising those issues here, and I think that's exactly right. I mean, it's not just, oh, you can't refer to that one statement. It's like you got to really alter your entire presentation to make sure there's nothing that, implies support for that statement.
In that situation, Amy, that wouldn't be knowledge of falsity for any of the other testimony, right?
I'm just saying that I think a correct reading of the notion, you just move forward but don't refer to it again, means you got to think that through deeply, not just strike one sentence from your closing argument.
So I have a question. I understand this to be saying, make the call of, can I move to, do I have to move to strike? Can I not refer? You tell that you make the call, I have to move to strike. The client says no. Say, okay, I'm going to move to withdraw then. Now, in Marshall's situation, if the court says no, you move to strike, right? Then doesn't the choice to the client be, I'm going to move to strike or you fire me?
No, I don't think you can move to strike without the client's permission. Does anyone?
No. Well, so what do? Then you just don't refer to it, even though you've already
Yeah.
decided that you can't do that under the rules?
No, you can do that if that's what our prior opinion says, is that
Yeah,
if,
I'll get back to my potentially irrelevant comment, but you'd made a comment that I think this warrants further discussion. You can't move to strike without the client's consent. How is that different from not referring to the evidence when the client insists that you do so?
That's a great question. A client.
Can I answer my own question in a way?
Yeah, sure. That's in fact that'll help me considerably if you answer your own question.
I really think at the point where the court's denied your motion to withdraw, you are now, if I'm reading what you're saying right, charged with the ethical obligation essentially to do the right thing. And the consequences down the line are what they are. And so I think consistency would be that the lawyer has to do ethically what they think is appropriate, which is not mention the evidence, and if they think it's really required, move to strike it.
but how do we think about that in terms of the duty of confidentiality? Does that disclose a client confidence? I mean, that's the issue, right?
Yeah, depends. That's great. Amplification of the issue, because then the question is, how do you know it's false? If I maybe should study this further, but if this is premised on you learned it was false from the client, then that's one thing. But if
And
you
it
learned
is.
it was false from a third party, then that's a
Yeah,
different.
you actually, and the fact, as I recall, is the client tells you, I heard it was false, and the lawyer goes and confirms it with the witness.
And I think actually under our stuff, under our opinions and stuff, even if you learned it from the witness, you learned it, it would be detrimental, it's information detrimental to a client that you learned in the, in the representation. So either way, it'd be confidential. I don't, yeah.
And I don't want to get too far off the point, but the motion to strike or withdraw the testimony, I'm a government lawyer, so I don't know the subtle distinction between those two, if there is one. I'm compelled by what Marshall is saying. This is the one thing that's bothered me the most about this opinion. So just hypothetically, you move to strike. Whether or not that's quote unquote revealing confidential information, I think is open. I'm open to the point that it's detrimental to the client, and therefore it falls under the definition of confidentiality. I just am curious, is there a way to strike or withdraw testimony without revealing the reasons why? Your Honor, we're no longer relying on that. End of sentence. I don't know if that's sufficient. Maybe you need more than that in any time you're going to strike or withdraw. But would you be, quote unquote, you wouldn't be saying why. People may infer, but you're not saying why. And then second, and this is what bothers me the most about this, it would be detrimental, embarrassing or detrimental to the client. Well, the client is not entitled to an unjust result. So we're turning the protection and the purpose of the duty of confidentiality, which I always view as a sword, as a shield, is now a sword in this example. You're saying, oh, and now the client is going to be able to benefit from a lie, an untruth that was introduced as evidence, shouldn't have been, and now this very important ethical obligation an attorney owes their client is going to be the reason why we can't correct the record for the judge to make the correct decision. It's very similar to disclosing, in my view, disclosing pertinent case law that's contrary to the position you're asserting. Of course, that's detrimental to the client. There's a case out there that says the exact opposite of what you're arguing, but you have to disclose that. Why? Because you need the judge to make, you don't need, you want just results, and you want the law to be correct to the best to the best ability that we can. And so I'm not saying I have the right answer. I'm just saying I'm unconvinced that the duty of confidentiality, the client could say, introduce testimony X. And I know it wouldn't turn on the duty of confidentiality, but as the quote-unquote captain of the ship and your ethical obligations of not introducing false evidence, you would say, no, go pound sand. I'm not going to introduce that. So here the client is saying, leave that false information testimony in the record. It bothers me that we would not also say, no, I can't do that. I owe, this duty to the justice system, for lack of a better word.
Those are all powerful comments. They really are. I never think it's that pure, though. You've got a situation where the client. I mean, what we typically have, well, first of all, there's no difference between withdrawing testimony and striking. If I told a judge we're going to withdraw this testimony, the judge will say, yes, true. Does the other side agree? Yes. Then that testimony will be stricken. Okay. So when we've spent more than one meeting going over whether the captain of the ship could extend to striking testimony that's in the record over your client's affirmative objection. I don't know whether it does or doesn't. I know that there's the footnote 16, Supreme Court, and when I researched this, the Supreme Court talks about something that would impair the client's substantial right. And what you say in response was no client has a right of any weight to put forth a perjured case. But the client doesn't have a perjured case here. It has one witness, and I can see a client saying, "Oh, I get it. Yeah, I don't want to rely upon that." But if we strike it now, after we made such a big deal out of it, remember there was zealous cross-examination of that witness by your opposing counsel. When we strike that, it's going to be really embarrassing, and that lawyer is going to argue that we tried to perpetrate a fraud and we only backed down after it was called out, and they will use that relentlessly through the rest of this case. And I don't really know whether it's going to make a difference if it stays in, but I'm with you on never referring to it again. I don't want you to go near that. And that's why I say it's not pure. It's not, there are so many gradations here that I don't think we can always say that you have a right to strike it. If you look at what we wrote on page 8, someone would say, well, can you strike it or not? We don't ever really say you can't. Mm-hmm. We suggest, we say it'd be perilous for you to do so until there's a new opinion from a court of appeal that would say, in these circumstances, we think lawyers can strike.
Your opinion referring to the earlier COPRAC opinion says, effectively, the attorney must conduct the balance of the trial as if the testimony had been stricken. And I think, Andrew, you bring up a point. You can simply move to withdraw the evidence or not, have it stricken without any explanation, because obviously the other side's not going to object. So the real Hobson's choice is, can you do that after Blanton? But see, Blanton was an extremely different set of facts. Blanton is a lawyer entering into a settlement. That's way different than a lawyer being asked to perpetrate or be a participant in potentially a fraud on the court. So you're right, there's no apparent decision on this, but we should be able, I would think we should leave it open to the lawyer to make a motion to withdraw the evidence, because that's the right thing. You're not facilitating the perpetration of a fraud on the court. I think the opinion should consider leaving open to the lawyer a motion to strike after the court has denied their motion to withdraw.
I think so too. I think if you've already determined that it is not a likely violation, but you know that it's a violation, to not refer, to just simply not refer. If you've done that analysis and you say this is an A situation, a mandatory withdrawal for me to just not refer to the evidence, I must move to strike. and the client says no, you move to withdraw, you don't get withdrawal, you're now back in a situation where you're going to violate the rules if you just simply don't refer to it.
I think that's why it's also for the reasons why a lawyer, if you've done everything you can and you seek to withdraw, court won't let you out. Then someone would say, well, if you strike, if someone wants to show me a case that says a lawyer has a right to dismiss a cause of action against a client's instructions, I suppose one could look at it like this. I haven't thought about it like this, is that once you decide, I think don't we have an opinion on this? You conclude that a case is being maliciously prosecuted, and then you say, we got to stop the case. The client says, no, we're going all the way. This is in the middle of trial to make it even harder. You have to seek to withdraw, of course. The client won't follow your instruction. The judge denies it. What do you do at that point? I'm going to call the clerk and tell the clerk to dismiss the case? You can't do that.
Well, I wonder if there isn't a use issue here too. I mean, it's not just disclosure, but kind of bothers me. I mean, I understand the comments that Andrew was making and the notion of having the process be, just or pure or what have you. But I mean, there's an aspect of this that sounds like you're using. I mean, if we agree that this is confidential information, it's not just disclosure. You're using it against the client, not only against their instruction, but against their case.
In effect, making a balancing analysis between our duties as lawyers to the process and the court to a lying client. When does the line get crossed, if ever, where our duty is paramount to the court in the process?
Well, no, I mean, there are certain situations where that's pretty clearly mandated. I mean, to Andrew's point, the issue of authority and so forth, I mean, that's spelled out. I don't see that as exactly the same thing, but I mean, it says what it says. It's pretty clear, but I don't know here. I agree with Matt. I don't think you could just call up and say, I'm getting rid of this cause of action. And we have other opinions that talk about, other counsel potentially coming in when the lawyer has a mandatory withdrawal situation. So I don't know. It just sounds, there's an aspect of it to me. It's like you're using the information against your client. And the scope of the duty of confidentiality protects all sorts of bad information about clients. We don't get to make a judgment call, but this is a good aspect of my client or what my client's done, et cetera. So.
I want to say, microphone. Oh, sorry. It feels like, I want to say first, Matt, I really think this is a very unusual and excellent job that you've done. It's very rare to have an ethics opinion that actually gets so deeply into what lawyers actually have to think about in this situation and just not be bland. It really reads like it was written by somebody who really understands what it means to be a trial lawyer, and I think it's excellent in that way. I think the answer to your point, Andrew, is that California has made a different choice than almost every other state on this issue, right? And they made it very deliberately, just last year, right? They are absolutely clear that the duty of confidentiality does not allow you to disclose, and that creates, I think Matt has it exactly right. If we were giving advice to a lawyer, you'd have to say, that's a real professional risk moving a strike if the client, and that's exactly what the opinion says. It's a real professional risk. So it feels to me like we're actually in sort of just the right place. But I think Adam's point is really good. right? If you think about it, if you get to the place where your analysis, you go through the analysis and you actually are required to withdraw because you're going to be violating a professional rule if you continue in the case, even in the non-referral situation, right? That's a truly hard, creates a different situation, right? Now you'd have to say, at least you'd have to say the professional risks have shifted. You might say it's perilous to move to strike, but it's also perilous to continue if you conclude that you're going to violate the rule. And one way we could, I don't know that we have to resolve that. I don't know how often that issue comes up. We don't necessarily have to get all the way there, but we could say at that point you might have to revisit the question of whether to strike. I think that's a fair point at that point, because you've tried your best to not do not violate the client's duty of confidentiality. Now you're locked in, and you've got two ethical violations pointing at you, right? And you got to figure out which one, how to resolve that tension.
But I think, don't the rules, it works like this. You have concluded that continued representation will violate the rules or the State Bar Act. You have to move to withdraw.
Yeah.
You move to withdraw, and you enunciate why you're doing it to the extent you can. Okay.
Which is not very much.
You're gagged when you do it. Okay. The court says no. Which is high, in the middle of a trial, who knows what a judge will do? Unless, if they don't know why you're doing it, they may well deny it. You have complied with the rules. That's what the rules say. And because you won't refer to it again.
Yeah, I think if there was anything, from my perspective, if this discussion has suggested anything, any change to this opinion, and I'm not sure that it has, it's that we need to do a little bit more than this tidy, if withdrawal motion is unsuccessful, then the attorney might not refer or rely to the perjured testimony. I mean, we do so much work saying how that may not be enough on page 10, and then we just kind of breezily say, okay, well, you did your job, you asked to withdraw, so just don't refer to it and you're good. And I wonder if that, I generally think that that's basically the right conclusion, but I think we might want to just complexify that a little bit.
How so?
Really great instruction, isn't
How?
Just complexify it.
Well, what's been suggested that would give it a little more oomph or nuance would be to say, go revisit whether you can move to strike. I want to say, when you read the Blanton case,
Yeah.
and you remember that this is crucial testimony,
Yeah.
that will decide the outcome, you are, at least ignoring whatever context Blanton may be in, what would be important to me is the soundbite from Blanton, which is that you may not stipulate to a matter that would eliminate an essential defense, nor can you stipulate, therefore, to something that would eliminate an essential claim. So you can't strike something over your client's objection that would have the effect of deciding the outcome of the case.
I totally 100% agree with that.
Yeah.
All I think is that we should say, echoing what you said on the previous page, that the lawyer needs to think about all steps that they can take to to not further rely on or cause the trier of fact to rely on that perjured testimony. So I just think there's a tidiness to the, don't refer to it anymore, which is from our old thing. But we're making a much more nuanced point here about how that testimony is sort of in the entire fabric of the case. And if the lawyer's trying to go forward but not have the trier of fact make the decision based on the perjured testimony, maybe you can turn that one off until, thanks. Anyway, that would be my one suggestion.
I can see a way to solve. I'm sorry, Justin.
Yeah.
No, I was just thought of a tactic, but it's that one could employ. But you could, if I was giving closing statement in these circumstances after fighting with the client, my motion to withdraw is denied. I would make the argument to the jury, because the other person then talks about this witness who no one should believe. It's a key witness. I don't even mention this witness, but when I do my rebuttal, I would say, feel free as a trier of fact to ignore that testimony because we don't need it to win this case for the following reasons.
Actually, you have two versions.
But I just want to say I haven't stricken the testimony, but I've waddled the line. The line.
I mean, the reality is that you have to we can't predict for everybody
Right.
anything,
Yeah.
which is, I think, what's the quality of this opinion, is you've said that. But, I wouldn't live or die on my suggestion at all, but I do think that
What I would do, Amy, is probably add a sentence that reminds the lawyer to at every step to be thinking about the questions that we posed further back in scenario 3 about, do everything you can to stay away from anything that might that could look like you are endorsing or relying upon the testimony. I'd probably, so they can't, just like to address the concern that definitely has been raised here repeatedly, which is, how you may enjoy the ride at that point. If you're a bad lawyer, you go, well, this is great.
Yeah.
This is great. We're going to win this case, and I've complied with my ethical duties, and my contingency is going to be so wonderful.
So I like your approach, Matt, in response to Amy's suggestion to talk more about the other steps, raising questions rather than going into recommendations about legal process during trial. I think we want to stay away from that, particularly suggesting a motion to strike or withdraw evidence. I'm concerned about us stepping into discussion of specific legal process. So I think we're also, in reality, how would that work? Heat of trial, who's going to be in the courtroom? Your opponent, and they're going to hear you moving to strike or withdraw this evidence. And guess what? That's going to be a red flag to them. They're going to recall that witness, find out what just happened, and make them look non-credible, and blow that what apparently was crucial testimony up, and make that witness and your side just look awful from a credibility perspective, assuming they can do that and there's no unduly prejudicial aspect to it that gets it excluded. So I'm concerned about us stepping in the process and what might actually happen at trial if you tried to move to strike or move to withdraw evidence.
Well, I think, because I don't know how we'll ever get this one done today, but what I would do, I've thought about this, and your comment just triggered this. What I'd say to a client is, we're gonna turn this to our advantage. We're gonna show what good citizens we are, because that's the way it needs to be, and people should get points for rejecting the use of perjured testimony. Because I got to tell you, if you don't do it, here's the way it's going to play out. Just like you said, like really cagey defense lawyer would say, "I'm calling that witness back."
Yeah.
They go talk to him in the hallway. Hey, what's going on? And then they call them back. And the jury will go, "I wish you should have told us it was perjured, rather than just strike it. You can, something like that."
Well, if that's what if that's what you did, then great. That's the best outcome.
Well,
the trier of fact has gotten the true facts, and
well,
if you win, great.
I wish life had happy endings.
Yeah, but anyway,
I have two comments. I like the point that you made, Drew, about 1.8.2 and the use of the information. I think we need to add that to the section on confidentiality. So it's not just a matter of, again, keeping the secrets, but how you use them. And I think it's important to refer to that here, because it's not just, and that language is to the disadvantage of the client. It's not, and that really should be the emphasis as opposed to whether it's embarrassing. I always find that language specific to certain facts, but not all of them. So, but I do think it would be helpful to add that to the sections like 6 and 7, just, I mean, even if it's a footnote or something, but we have the paragraphs about client secrets and using the testimony, that we could just add a reference to that 1.8.2, because that's how you, when you're doing that analysis, whether you would use that information that you got from the client in that way, which is what the consideration is, I think, on a motion to strike if your client said that they didn't want you to do that. And then,
Actually, I do, right, let me make sure I capture that.
okay.
Which is the, is that you need to have a discussion with the client about how, say it again.
Well, I mean, the question is not just about the, maintaining, I mean, there's then the new rules, it's the issue of, maintaining the confidential, maintaining the information is confidential, but it's also using the current client's confidential information, which is 1.8.2. So it's not just a 1.6 question, is I guess what I'm saying. And that I think is relevant to maybe this analysis later when the client has said, no, I'm not, you've tried to demonstrate, you've said this is the way we should do it, which is move to strike. The client said not to do that. At that point, you've made the motion. I mean, I think that it would be very difficult for you to, if you move to withdraw and that was denied in that situation, for you to move forward with what you're talking about, which is to still try to move to strike the testimony, because I think it is a question of using that information. And I'm not saying we necessarily need to say you can't do it, but I think the point that Amy made, which I think is a good one too, which is that we only make one comment, and there's one sentence in the last paragraph about if the motion's unsuccessful, then you must not refer or rely on the perjured testimony throughout the rest of the case. I think it would be, the point that I think you made and others have made too, which is like going back to the analysis, like you said, you did this great analysis. At that point, this attorney should go back to that analysis and say, what can they do? Can they use the information or not based on that rule and rely on it? And then kind of, I don't think you need to go through that analysis again, but just refer to that process or something like that, because I do think that that is information that you really could do that, meaning move to with strike the testimony. So I just wonder if it would be valuable to reference that.
Really, that's right. A motion to strike, when you, just like Justin brought out, is that it's so fraught with potential embarrassment and devastation to an innocent client who could be, in a misguided way, could say, well, I want you to use it. Because I mean, an otherwise honest person may actually, well, I guess that's preposterous just a little bit, but there are some relatively honest lay people who would say, well, it's not our fault that the witness perjured themselves. Aren't we allowed? No, I can see that. And then this whole unfolding of the spectacle of striking key testimony in the middle of a trial is always going to be adverse to a client's interests, whether they're good people or bad people.
Yeah, and I think that part of the conversation that you're obviously having with the client at different points in time before you decide that you have to withdraw is saying that you can't go forward in this way, and they have the choice to try to find other counsel or ask the court to continue the trial. There's other options that they, so the situation we're really talking about here is when your client refuses to let you out of the case when you've highlighted this information, but they say, I know you think that you know about these lies, you know about this, but I'm not going to agree to let you out of the case. Or you think that you don't have grounds under these rules, which I think we've articulated that you at least would have permissive grounds to seek relief to as counsel. But I don't know. I just, anyway, I'll take those comments. I think there's this is great. I think a lot of good comments have been made about these issues.
What if that line Amy was pointing out said, then at the very least, the lawyer can't refer to it and must consider whatever it says before and somehow refer to this situation before?
Yeah, I mean, I think that would capture the fact that our discussion today highlighted that it's, it's not a tidy matter and that it will weigh on the lawyer's conduct throughout the rest of the trial. So I think that is one suggestion for you, Matt, and then the other is Dina's suggestion that in the discussion of confidentiality, there be a reference to 1.8.2.
Yeah, I have that. I have both of those notes.
Now, should we move on to the other issue, which is the perjury versus falsity?
Yeah, that's Stephen's drafting, and it's fine with me. This whole process, is a bit like a ping pong ball because when we move back to say falsity, someone's going to say, well, that's not all false testimony is perjurious. Just like when we send this out again, if we fix it to what apparently we are with the changes we made, people are going to object. The portions of the public are going to say, no, you have to withdraw under these circumstances. We can't make all the people happy on these things. But anyway, with that, Stephen.
Yeah. Well, I guess I've been thinking about this for a while, and then I was spurred by Alison Bernstein's comment, basically saying she was basically saying nothing in the ethical analysis here turns upon the mental state of the witness. Right? It doesn't matter whether the witness is lying or is absolutely convinced they're telling the truth. And it doesn't matter that the testimony is material, actually, in terms of the duty not to put it on. The way 3.3 is written, the question is, does the lawyer know that the testimony is false? Right? Nothing about the witness's mental state. Right? And if the lawyer knows the testimony is false under 3.3, the lawyer can't put it on. It's that simple. And then it's the duty to correct that's triggered by materiality under 3.3, right? Or the duty to take reasonable remedial measures. So it felt to me as though by emphasizing perjury, right, we were emphasizing something that is actually pretty much inessential to the analysis and actually misleading, right? Because it doesn't matter. And it doesn't matter what it is. So that all these changes are basically simply designed to put the frame back on the rule 3.3. Have the analysis go from the text of 3.3 rather than from the term perjury.
I'm not sure I need to look at the rule to understand what the argument is. Let me see. Give my copy of the rule.
So is the question to consider whether every time the word perjury appears that we use the word like knowingly false statement, or is that what?
Well, I didn't try to take perjury out, but I did try to put known false, right, or known material false in at the places where it actually matters for the analysis, because that's what's driving. Since we're trying to explain what the rule requires, it makes sense to me to have the analysis at those points key off what the rule says.
Right, I agree with that.
What is the rules? I don't. I have it on my iPad, which I can't. For some reason, I can't get to it. I guess it's 3.3. Oh, I should have this.
Well, it says here's 3.3A3, right? 3.3A3. A lawyer shall not offer evidence that the lawyer knows to be false. That's the first sentence. So the only thing is whether the lawyer knows that it's false. It doesn't matter whether it's material. And that actually makes sense to me. Why would you ever authorize a lawyer to put something on that they know to be false? Ever. And so that's piece one. And then 3.3A3, the second sentence, if a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer knows of its falsity. So the duty to correct keys off of material evidence which the lawyer knows to be false. But there's nothing in there about about the witness's mental state at all.
Well, 3.3A1, lawyer shall not knowingly make a false statement of fact. Lawyer hasn't done that. Or fail to correct a false statement of material fact.
Right. We're not talking
Which-
about that. And we're not talking about failing to disclose legal
Right.
authority, which was Andrew's
And then
example earlier.
And then 3.3A3, then you have to go read the comments to understand what you actually can do. Tell me, what do these words, do these words impact the way we're analyzing this in any way?
Not the first one, except that, I do think, what I've tried to do, and we can walk through them, but what I tried to do was to capture every case where we suggested that the witnesses, the fact that it was perjurious was driving the analysis, as opposed to the fact that it was known to be false, or the fact that it was known to be false and materially so. Those are the things that drive the analysis under the rule. And that's what I'm trying to suggest the lawyer ought to be thinking about then. I don't want to suggest, I think, so the idea is to make the opinion, A, follow from the language of the rule, which seems desirable, and B, not to mislead people into suggesting that the fact that the testimony is perjured makes any difference to the analysis.
I do think,
Do you feel that way, Steve, on scenario 3?
Pardon?
Do you feel that way about scenario 3?
What, the fact that the testimony is perjured?
Whether seeking to withdraw becomes mandatory? Because comment 8 seems to suggest that it becomes mandatory.
There might be, I mean, there may be situations where it could make a difference in that way, but then you're analyzing withdrawal, right? You're not actually analyzing the duty to correct or the duty to take reasonable remedial measures
Right.
under 3.3.
But
And I don't think I got into it at the back.
At
I'm
the
only
back,
interested in making the Rule 3.3 analysis correct.
Well, that might be a point to clarify, because comment 8 suggests client misconduct on a mandatory duty to withdraw.
But couldn't the client misconduct be the refusal to allow the correction? I mean, here we have a witness who may, as we've all said, just gotten it totally wrong, as opposed to knowing. It doesn't really matter.
Well, it says here it's premised on I don't think we're taking any view. I mean, the revisions I made don't take any view on whether client misconduct would be irrelevant or, that's all talking about a lawyer must comply with respect to a request to withdraw. I'm only interested in making sure that the 3.3, whatever it is, A3 analysis is correct.
Do you think that when they drafted 3.3 and they talk about false evidence the lawyer knows to be false, and then it talks in 3.3A3, if a lawyer comes to know a witness called by a lawyer has offered material evidence that the lawyer knows of its falsity, that means anything other than perjury?
Yeah,
But it's-
absolutely.
It
I think
tracks
absolutely-
the
I think
ABA
it's
rule too.
absolutely clear that,
I think it's
you
clear as
had-
mud.
Well, I'll put it this way. You take the 18 people, including one of the people who's in this room at least, right, who were sitting around the table, an awful lot of those people are very experienced. You read those two sentences, right next to each other. One says you cannot present evidence you know to be false. The next sentence says knowing and material, you know to be false, and it's material. How could that difference not jump out at people, right?
Wait,
And
wait,
why wouldn't you say perjured, right, as a
But-
lawyer if you were,
But,
right?
but this entire scenario is actually dealing with with the longer clause, the full complete sentence in 3.3A3, which deals with what do you do after it occurs.
No, but that's not true because.
And that, can I just finish? And that has two elements. Knows it's false and it's material.
Yeah.
But it's the lawyer's knowledge. It's not
Yeah.
it's not the witness's
Okay.
knowledge.
Right, that's the thing I've been trying to stress, is the witness's state of mind is immaterial. It doesn't matter.
Well, that,
It may matter for other reasons, but it doesn't matter for the 3.3 analysis.
that distinction's in the ABA model rule as well. I mean, there's no question it was purposeful.
Yeah.
I mean, it's not a slip of the tongue. I mean,
So wait, but what are the implications of this to this scenario?
Look, I don't think that any of my changes change your conclusions about what the lawyer ought to do at all. I'm just trying to follow the language of the rule.
Well, the
Right?
implication.
And not to suggest that if there were no perjury, the lawyer would be off the hook.
That's right. That's it. That's what's.
Well, that's curious to me. I thought that's the implication of it. And our facts, actually, I'm going to make them even easier on the lawyer. I'm going to make it clear when I do this that the witness knows it's a lie when the witness offers the testimony. Because that's
Well, one of
Why
our
would you do
scenarios
that?
says that it's a lie and the other one doesn't. I mean, the other one just says it's.
I'm going to make that resoundingly clear. But I'm not sure. That's weird, a little bit weird to me. And maybe it shouldn't be. That I know a witness has offered completely wrong testimony. It's impossible. There's no way this is true. But that witness nonetheless believes it's true.
I have had that experience.
I have a
I
duty
sat
at that
it-
point
I sat it as
to
a
go.
very, not
I tell me what my ethical duties are. I don't believe I have
They're
any.
exactly the same.
I sat there.
Because I know it's false.
I sat
I
there.
know it's massively inaccurate. I know it's impossible.
What,
Yeah,
what,
it's
what, I
impossible.
don't understand what you're,
What's the
I'm actually
problem?
not sure why you're,
Give me the scenario.
Okay, I'll give you the scenario.
Okay.
All right. This is me as a very young, very junior lawyer, right?
Couple years ago.
Sitting next to the second chairing in a federal court, right? And a witness for our corporate client is on the stand, the general counsel, and he testifies. He testifies that he was somewhere where he was not, right? And he's obviously dazed. He's being brutally cross-examined. He's got a terrible record, but he ends up saying something, and we're sitting there looking at actually we have our billing records open in front of us for some reason, and we know that he was with us. Because it's right there in the billing records that he was sitting with us, right? And he did not know he was lying. He had no idea what he was doing. He was totally at sea, right? But we knew we had to correct it.
Because of 3.3 uses the word false, that means something greater than just perjury. It's just
Less than perjury.
perjury is a subset of that.
Yes.
it's a mental.
I don't, I wish they'd made the rule far more clear so we could put this debate to rest, but I don't think we can. I don't believe that massively inaccurate testimony.
No,
that-
known
that-
false
that-
testimony.
That I know the witness in good faith believes that state of affairs, or has forgotten, or whatever reason. I don't know that qualifies as false testimony. Within the meaning of these rules, such that I have to jump up
I share Matt's concern. In the scenario, Steve, that you mentioned, it sounds like what I would consider, without defined terms, inaccurate testimony, as opposed to false testimony, with, for me, has a connotation of intent. Do we have anything either in the rules or, you know, the ABA interpretation of the ABA rule where we can say that false includes just inaccurate testimony, like in your scenario, or what I think, you know, as lawyers we think false implies some sort of intent to be inaccurate?
I think the distinction I'm hearing you say is, to the extent there's any scienter involved, it's not with the witness, it's with the lawyer, that they know it's false.
That's the key, and that's the way the rule, that's the way the ABA rule is
Yeah.
written, and
But see,
on this, we've tracked the ABA rule.
when you're trying cases and everybody's live in the moment and gets confused and are stressed out, you're gonna hear evidence that you have a pretty strong gut reaction isn't correct.
Right.
And
But you
so,
don't know it to be false. That's the protection.
yeah, and so
That's
you
it. It's
assume,
the known to be false is a very demanding standard. I mean,
Yes.
we literally had our own, we not only remembered being with the guy, but we had our billing records sitting in front
and
of us.
you
We
assumed your
knew.
secretary entered the right date on the billing
Right.
record.
Right, yeah,
So you can go through that mental gymnastics.
right.
Well, doesn't the materiality distinction also speak to that? I mean,
Yeah,
that
but
shows
yeah.
that false means something more than perjury, because when it gets to the duty to correct, it's information the lawyer knows is false, but only if it's material as well. I mean, I think the way the rule is written shows that it's broader than, and then, you know, falsity doesn't mean perjury in some kind of specific intent.
Right, you can't prep a witness or introduce a document that you know is false and prep a witness to testify something you know is false. But in your situation, the witness on the stand and says it was somewhere, if it doesn't matter, you don't have a duty to go and correct that. You can't,
Right,
you can't
absolutely, sure.
possibly
No.
make a lawyer correct everything that was misstated in a trial.
Right, no, that's right.
I'm sorry, I'm not convinced. I'm just very quickly going to Black's Law Dictionary, right? What does false mean? In law, this word means something more than untrue. It means something designedly untrue or deceitful. Now, I'm not saying that that's our definition of false in the rules, but I'm not convinced that it's not. And so if we're going to take this approach and say false means inaccurate, I think we need more of a legal or, you know, confirmation that that's the intent of this rule. And I'm not saying anybody's right or wrong. I'm just saying we got to be sure about this.
I speculate that you're right, and I want to believe you're right. I think that the drafters, when they used false, were probably of the mind, they could have been of two minds. They may not have thought about it, but I guess they must have. They're all smarter than me. But I like the Blacks. That's the way one would make this useful and informative, because really, witnesses mess things up all the time in significant material ways throughout trial. Even really good, really, but I don't ascribe to them a perjured state of mind, and I don't sit there and go, I now have an ethical duty to make sure that their testimony is consistent with what I believe the true facts to be. I don't believe that.
Can you turn off your mic so, because otherwise we get echo. You got to check off two boxes. You got to check off, you know it's false. Not, it might be you have a view that it's different, and it's material. And at that point, you check box, I was there, and I saw it, and someone else did what that guy just described to my client. So one, you know, which is a very high bar. Second, it's material to the outcome of the case. You check both those boxes, and you say, you're the lawyer, no duty to correct, just because you think the guy who just said it was wrong. Is that right?
I hear what you're saying, and I'm not disagreeing. What I'm saying is that just looking at the rule and looking at, you know, a basic definition of false from Black's Law Dictionary, I'm not convinced at what the intent of the definition of false is in Rule 3.3. And I don't know if we can look at either the executive summary or some sort of interpretation of the word false in the ABA model rule context or otherwise to give us more of a legal hook to understand what it is that is meant by false. Does it truly mean just inaccurate, such that inaccurate but material evidence triggers an obligation under 3.3, or must there be a knowledge of the lawyer that not only is the testimony material, but there was something designedly false, designedly untrue about it, and which is a very different bar than inaccuracy in terms of triggering a 3.3 obligation potentially. So what I'm saying is, I think we need to look a little more closely and see if we can find some sort of precedent to help us define this before we move forward.
My comment
It'll probably be in the Old Testament.
Well-
Thou shalt not, or the New.
Yeah,
Sorry.
Just a comment. I look at the fact that we have the A section. Well, we also have the B section, which seems to discuss, specifically talks about criminal or fraudulent conduct, which seems to which suggests to me that A and B are talking. A is referring to a broader category of false representations than would fit under B. B clearly would include perjury, criminal or fraudulent conduct. The fact we have A and B suggests to me the definition of false is not limited to stuff that is intentionally willful under the penal code section. Otherwise, why wouldn't A and B be kind of superfluous? I don't know.
I also think you need to remember what this rule is. It's candor to the court, right? It's the state of the obligation of an attorney to make sure that the trier of fact is not misled. So how could that turn on whether or not the witness state of mind?
I completely understand the interpretation by looking at the words of the rule. What all of you are saying make perfect sense to me. At the same time, if we can confirm as much by looking at how these terms have been used to the extent there is precedent, I think that would be a safeguard to make sure that courts or other jurisdictions using an ABA model rule that's similar to 3.3 feel the same way, so that we're not going inadvertently in the wrong direction, because this common sense definition that you're explaining, we just need to be sure that that's right. That's all I'm saying.
It's either the 8th or 9th commandment that says, "Thou shalt not bear false witness." That I'm absolutely completely sincere about this in offering this as an argument, because I agree with Justin. If you look at the derivation of what a false witness, thou shalt not be an inaccurate witness. Thou shalt only speak when you know your facts. Thou shalt never contradict yourself. False witness implies a state of mind, a deceitful state of mind.
Turn off your mic. This is not talking to the witness. This is not a commandment from God to the witness. This is a commandment from God to the lawyer. So this is what the lawyer has to do. And the lawyer has to not allow the court to be misled.
We need to resolve this question for the purposes of this opinion.
Point out. Well, I don't know.
Well, we do just resolve whether to make Steve changes.
All of Steve's changes.
I would point out,
yes.
Steve captured something brilliant, which I did not see in Allison Bernstein's comment, talking about plain reading. I took Allison Bernstein's comment to be whether the witness knows the testimony to be false is relevant for it to be perjury. That was the only thing I took away from that comment, and you're very smart, and I'm impressed. You've inferred from that, now the lawyer's knowledge of whatever has been presented is to be applied under 3.38. I don't think that's at all what Ms. Bernstein was referring to. So she's saying in your analysis you go from false to perjury, but when you do that, you don't talk about the witness's knowledge of what they're testifying to, which, and I looked up perjury because I'm a government lawyer and don't deal with it very much, does require that the person testifying knows it to be false. There are, several elements, as you're all aware of, and that's one of them. And we don't flesh that out in the opinion. And that's the point I thought the public commenter was making, not this difficult point.
If you just take the first sentence here, a lawyer shall not offer evidence that the lawyer knows to be false. Start just with that. I'm not sure it makes sense to understand the word false in the definition that Blacks uses. If you just take the first sentence, I understand how you can get wrapped up in that as you get into the explanation. But to say a lawyer should not offer evidence that the lawyer knows to be false and interpret it in any way other than he thinks that he knows that the information is inaccurate or incorrect seems to me to put a layer on there that doesn't make sense. That's non-lawyer analysis to me. I'm sorry.
All of Stephen's changes are fine with me because the word false is in the rule, and I think that then the rest of the opinion trends towards it's perjured, okay? So it's going to be easy for you. The one sentence I do disagree with, whether I disagree may not be relevant, but I do think our discussion illustrates the reasonable minds would definitely differ, is on page 4, and I think it's in the second paragraph, the last sentence, because the lawyer knows the testimony would be false, Rule 3.3 would bar its presentation, whether or not the testimony is material or the witness mistakenly believes it to be true. And I just don't want to say that. It's not necessary to resolve that under these facts. We don't need it, and that's the lawyers. You can't offer testimony you know to be false. That's right. That's exactly what 3.3 says, but it doesn't. What 3.3 doesn't say is that even if the witness mistakenly believes it to be true. We've all had trials where you go, I don't know how that witness can really believe that, but I don't know that they're wrong. Yeah, I think it's unnecessary to this, and I think it will be misquoted or misused in a way that, no, it won't be misused. But I think it tries to resolve exactly the dilemma that some of us have with because false, again, I think false evidence must mean something other than inaccurate evidence. It must mean perjury, or it must mean.
Why don't we just take off that last, or the witness mistakenly believes it to be true, that part of the sentence? Because the other expression of that concept is accurate in terms of the rule. And if you think that last part is, opens up more questions about what the witness mistakenly believes or not, that's not really our facts here. The facts here are the witness says that.
I know it's right.
But the facts here are that the witness said,
So if I
admitted
tell you
that they
you're right,
lied.
then we can go through.
No.
Doesn't,
Look, I'm happy with you.
So we wanted.
If you want to take that last piece out.
I would take the whole sentence out if I had the final vote. The 3A says material fact. And
Not with respect to whether you can present it.
pardon me?
Not with respect to whether you can present it. Read 3A3, read the first two sentences.
3A3.
And tell me the difference doesn't jump out at you.
Wait, you're talking about 3A?
Okay. Concede.
Well, I wonder what 3A1 means. Knowingly make a false statement of fact. I'm not making it's the witness that's making the false statement of fact. I'm not making the,
I'm sorry, 383.
383.
Opening or.
Offer
Right.
evidence
One
that,
is the lawyer speaking in his or her own voice.
yeah, you're right.
I would like that sentence to just read, to either strike it, because the lawyer knows a testimony would be false, Rule 3.3 would bar its presentation, period.
And I think it's important to actually put in a lawyer copy. That's helpful guidance for people. I agree.
So it sounds like you, Steve, would be.
Okay with taking out
I thought
the
Dana's change was
last,
just fine. Take
You're-
out
or the
or
witness mistakenly believes it to be
Yeah.
true.
Take
Okay.
out the or the mistaken.
Your point is 3A3 has no qualifier on materiality.
Right.
I mean, we may not like it, but that is what it says.
Let's-
Well, no qualifier as to offering.
Right.
Then it goes on to have a qualifier of
Right.
materiality with respect to correcting.
Correct.
But it says. I cannot keep
Concede.
telling people what the bill says.
So I heard what everyone said. I will work on that sentence, so we'll be able to move on.
All right, so I think that's, okay, last opportunity for comments on this opinion. And I think
We're not voting this out to go back out at this point, because I think there have been a few salient suggestions. Do you agree with that, Matt?
Yes.
Okay, cool. All right,
Matt, you should understand, this is, I think it's probably the best opinion I've ever read on this topic. I mean, there are a lot of lousy opinions out there. And this is really good. This is really, really good.
I really appreciate that. It's, but it's, I always liken it to building the Winchester house. We're- or Sisyphus, rolling the rock up the hill.
If you can somehow figure out how to put the commandments in.
You're assuming you'll never get to the top.
Right. What?
You can figure out how to put the commandments into this agenda, some of the rest.
Yeah, I agree. Let's go that. Let's go that. Okay, so let's do, yeah, well, we'll see. If it's dragging on, we'll just stop. That's all. I don't want to keep training, but let's do, ancillary business. So numbers, page 55, amendment 2.
Steve, take it away.
All right, all right, well, so I just want this, nothing really has changed in this draft from the last time we discussed it. What I mostly what I've been trying to do is to deal with Andrew's very, very thoughtful and penetrating comments that have been quite deep. And so most of the changes you see here are reflective of comments that Andrew's comments or Randy did before, which were all excellent. Now, I think that there are two areas where Andrew would have felt that there could be more, I should have done more that I didn't do. One is the question that was really raised very powerfully of whether the opinion oversteps in suggesting that in the case of a lawyer fiduciary, right, who is acting not as a lawyer but just as a fiduciary, the question is whether rule that out. And that you can, in fact, lawyer fiduciary could.
I'll make a couple comments if that works. I really like this, Steve. I think it is. I think it's excellent. I think it's really important. Particularly in preparing for the symposium topic that I had tomorrow, it touches a lot of issues that I think, hopefully some of those gaps will be bridged by some of the recommendations from the task force, but this is really important, and it's an important opinion to be out there, and the analysis that you've given is really great. On the issues that you discussed related to fiduciaries, I'm satisfied with your analysis on it. I think it's the right analysis on that, and I think that particularly compelling for me is the idea that why are we substituting our own judgment related to how this structure should work when there's other structures in place on that. I think that and that's the one that I wrestled with a lot last time we talked about this, is like how to fit that in. But I like this and the way you've done it here. So I ultimately agree with the analysis and the conclusion. I think one area that I kind of struggled with when I read it, and it's kind of a language issue, I think, was when I read through it, and when there was this constant reference to like how attorneys can avoid the application of the rules, I felt to myself like I don't like the way we say that, and yet I couldn't think of I couldn't think of a better way to say it. But I ultimately was thinking that because that concept is repeated, that one idea I had was to reference in a footnote or something like that to say, and I know you make this clear in the introduction, but to say something to the effect that we're clarifying that when we're talking about avoiding the application, it relates to the application of the rules that are intended to regulate the practice of law, because I think, or something of that effect, where we're saying that the rules that are intended to regulate the practice of law are what we're saying wouldn't apply to these, legal services and these non-businesses, as opposed to other rules that generally want to regulate, the issues you raised related to moral character, 8.4, some of those issues which are generally intended to regulate lawyers' conduct within the profession. So I don't know if that's the right language, but I feel like, and rather than to mention it every single time, like avoid the application related to the practice of law, we could maybe say in a footnote somewhere early on that when we're talking about that concept or referring to that, we're talking about, the way in which the rules related to that, the practice of law wouldn't apply to that attorney because they're not actually practicing law in that context, or, something to kind of further explain that.
Well, how about right at the start, in today, the defendant addresses those rules of professional conduct, right, that apply to lawyers in the practice of law. Right? You like that?
Where are you talking about specifically?
Right up to the introduction.
Okay, yeah.
53 is a minute under which those rules of professional conduct that apply to lawyers who are practicing law, who are engaged in the practice of law.
It's one of those things where, and I think we all have these concerns at various opinions, where when someone picks it up and looks at a sentence, and the suggestion that we're trying to avoid the application makes it seem like there's some, I don't know, a nefarious purpose or something behind it, which I don't want to suggest. And again, I couldn't think of a better way, to refer to it in that way, because you're really talking about, engaging in professional activities that really are outside of the practice of law, and that you shouldn't be bound by the rules that are intending to regulate the practice of law related to confidentiality, trust accounts, the stuff that we've all been talking about. But you definitely make it clear in the digest too that there are certain issues that are outside of this. I just thought maybe we could reference it again at some point to make that clear.
I'm putting it in a couple of places.
Okay. Okay.
I think that the place at line 55, right? I put it in to say rule 50, line 53, excuse me, which those rules of professional conduct that apply to lawyers in the practice of law, right? And then at 122, I think we could do the same thing. In addition, under certain circumstances, lawyer or law firm involvement in business providing can trigger the application of other rules of professional conduct applicable in the practice of law. Well, can you get either of them? No. Here, so. There you go, Ted. You done the 53 one? No.
I wasn't sure if it was a new sentence or it's a replacement.
No. So in the first line of it says which the rule in 53. It says under which those rules of professional conduct, and then following the word professional conduct, that apply to lawyers in the practice of law. So that would be the first change, and the second change would be 122.
So that, and then the rest of the sentence is breaking or not?
No, the rest would stay the same.
So a comma then?
No. No, it just. Why?
What about those rules?
May also apply. A lawyer's conduct in providing non-legal services. The kind of thing that helps from your perspective.
Well, I think it was my reaction to just the language. I guess I was more comfortable with the language when we're talking about that it would be outside of the rules of professional conduct, as opposed to saying how can they actively avoid the rules. And And so I was just trying to think of the language on that, and I wanted to make it, I just thought making it clear again that we're talking about the rules, those rules, because not all the rules simply regulate the practice of law, that there's some rules like 8.4 that talk about general lawyer conduct, yeah.
That's what I'm trying to say.
Yeah.
That's what that language is.
Yeah.
But Gina, is it that part that bothers you, or is it the word avoid? Which, by the way, I agree, but I've racked my brain to come up with a better word. And I think the subcommittee
Yeah.
talked about that on a call, and nobody could figure out a way. It does make it sound like you're trying to sneak around, but I guess my conclusion is, like, if you really read the opinion, that's obviously not what we're saying.
Right, and I think it didn't, when I read these introductory comments, it didn't stick with me, but as I read, like, affirmative steps may avoid the application of the rules, that's when I thought, well, maybe at some point we could put in a footnote saying when we say avoid, we're talking about, it's specifically related to those rules that are intended to regulate the practice of law. But I don't, I mean, it sounds like you guys have discussed that. I don't know if other people have ideas about a different way to frame that, but I couldn't think of one either. But it just,
I've tried a lot.
I know, I'm sure.
I just haven't been able to come up with a better way to frame it. I do think it helps to make clear that we're talking about are the rules applicable to the practice of law,
Yeah.
right? Because that's really the issue.
Right.
What should you be treated as a lawyer engaged in the practice of law when you're not practicing?
Right.
So the other place I was suggesting that you could add language, at least at first glance, in 112, at the end of the sentence, which reads other rules of professional conduct. Applicable in the practice of law.
I mean, I can see a place in the conclusion too. I don't know if you want me to separately point out some spots, but off, yeah.
My guess is I think we should see if we can get to lunch. If we could make those a few more changes like that over lunch.
Okay.
And we could also search for some approach to the word avoid. That would help. But I think we should, if we can, we should look at other substantive objections we have.
Yeah. Okay. Sorry.
And so I had another comment. I'm trying to see my other comments. On lines, Steve, 372 to 374, there's this line talking about where the customer is not sophisticated, it may be relevant whether the customer had or was advised to retain separate legal counsel in the matter. Is that, I'm just wondering where that came from. Is that a rule that we're talking about?
No, it's more a rule of something that would be relevant in the rule of reason analysis.
Okay.
Without trying to suggest, right, whether it would be essential.
So if you had a sophisticated client, you're saying you probably wouldn't have to suggest that they retain separate legal counsel, but.
Right, or they might actually have counsel.
Correct, yeah. Uh, With respect to the rule of reason, I just wanted to make a final comment that I agree with that. I think it would be kind of challenging to set forth a lot of specific rules on this, and I think the analysis shows that there's issues that need to be considered when thinking about through that and how you would, effectively convey clarifying measures, and a lot of that would have to do with sophistication and these other issues that are implicated. So I'm in favor of your approach on that particular issue. And then I thought I had something else, but I'll look at my notes, but I'll take my comments off.
All right, are there other people who want to offer any comments on this revision? Drew?
I have a couple, just because I think it's so close. On page 4, line 116, we're referencing 8.4, and I'm not sure, but I didn't see any quote to the actual language, and I just wondered if somewhere we should be dropping a footnote just to let the readers know what does 8.4 say. We cite the comment here saying that 8.4 applies by its own terms.
Okay, I think that if let me put in language from the rule over lunch.
Yeah, no, I mean,
Makes sense.
yeah.
I think that's a good idea.
Over on page 8, on line 278. Oh, is it? Is it?
8.4 comment 1. Sorry, just following up on his comments.
I've already cited.
He cited that. I guess my point was just if someone's not as familiar with the rule, they're not going to know, okay, it applies by its own terms, but what applies?
Right.
You know. So on page 8, line, the sentence 276 to 278, we say in both scenarios 1 and 2, then there is a significant risk that the customer could misunderstand the nature of the services being provided. I just thought it might be helpful to add and construe them as legal services. I mean, that's the point, right?
Yeah. I think that's fine.
Just to the end of the sentence,
So
right?
it's at the
Yeah.
end of 278. And construe
Got it.
services.
The construe?
Got it.
Then on page 11, line 376, I just wondered about this. We say in scenario 2, the law firm has expressed an interest in, and I didn't know if our facts changed. And I was going back, maybe the law firm proposes to have one or more lawyers. I think maybe originally we had this kind of, someone's asking about this in a way, and I don't know, it's just express an interest.
Right.
Didn't seem to coincide.
So let's look back and see what makes most sense.
I thought it was just propose.
Propose, yeah.
Propose?
The law firm proposes to have,
It's better. Proposes to have, I should say.
and then in the next paragraph there, starting on 386, this is an issue that got fixed a long time ago, but I think there might be a holdover here. This paragraph has a couple places, and can do this over lunch too, but where we're talking about application of the rules to the business. And at one point, we were careful to go back and say it's the application of the rules to the lawyer's conduct with respect to the business. I mean, the business itself is not regulated by the rules. So like on 387, for purposes of,
Just have to say apply.
yeah, or apply to the lawyer's non-legal business activities, whatever. But yeah, that's fine. But
So just drop those next 4 words. There we go.
yeah, so that's, I think that you have that on 391.
391 should strike the same language, meaning at the end of the sentence, 391 to 92, to the non-legal business should be stricken.
Yeah,
It just says apply.
yeah. Okay, over on page 12, on line 430, we say because the communication cannot be understood as offering legal services, I just wondered if we should insert reasonably. There it goes. My last comment was just in the conclusion. At 487, well, okay, just conceptually start out by saying a lawyer engaged in a non-law business is always subject to professional discipline for conduct that violates 6106 or 8.4. Then we say a lawyer's involvement in a non-law business may also trigger the application of other rules of professional conduct if the business is sufficiently law-related, et cetera, et cetera. The way it was set out at the beginning was if the non-legal services are provided in circumstances that are not distinct from the practice of law, or you're dealing with law-related services that are or services sufficiently law-related that there's this risk. I just wondered if you wanted to mimic that language. I mean, the first is kind of subsumed in the second, but I mean, if you look at the beginning, we have a whole section that starts by saying one way they can apply is when there's no distinctness.
Well, the first
Does that
thing
mean-
is that it has to be law-related, right?
Right.
And then you come away, you don't even get to the distinctness analysis, right?
Yeah.
Or the clarifying measures analysis unless you have that. So if I
Right.
wanna, this is the classic from the 1995 opinion, if you're running a dry cleaning business. or a
Right,
restaurant,
right. Yeah, no, I'm okay with that. I sort of thought the same thing, but yeah. So that's it. Those are my comments.
So we're not making anything.
No.
Anyone else? Personally, I thought those changes were great, and I'm totally satisfied with the analytical way that you've approached this, and I think it's very, very careful, and, I think it'll be super interesting to put it out there and see what.
I can't wait to see where
Yeah.
it's come from on this one.
Yeah.
No idea.
This is going once, going twice.
So, just circling back to Dina's comment, I mean, I've raised my concerns, and they've been heard, so I don't think I need to restate them, but, I do have concerns with the paragraph Dina raised, and it's on, and I raised this for Steve. I appreciate Steve taking many of my comments under consideration. So two of my big comments were whether or not we should list specifically what needs to be disclosed, a bullet point approach. And for a variety of reasons, Steve disagrees, and that's fine. But on my version's slightly different. I'm at line 370 or thereabouts. So it's this paragraph in your version. It starts at 363 through 374. And I am pretty concerned about this paragraph. And the comment I shared, I'll just read the comment I shared. I'm very concerned about this language. To me, it appears muddled. It does not provide clarity to the reader. It does not appear to provide clarity to the reader or sufficient guidance. And this is my concern. Do the clarifying measures work or not? Do we need a separate type of disclaimer for a sophisticated client versus not sophisticated? I think, a strong disclaimer should be given in all cases. We're saying, oh, it's a rule of reasonableness, and some people are sophisticated and some are not. The problem is, my biggest concern is it's such a sea change from the existing law in terms of the application of the rules, as has been stated by the Supreme Court many times over, as well as with the Family Law Facilitators Act, which I apologize for not including in this meeting's materials, but we included in last meeting's materials. We just didn't discuss the opinion. which notes that a family law facilitator must disclose that they're not acting as a lawyer, but nonetheless, some of the rules are going to apply some of the time. And so, knowing all that, I just wonder from a client protective perspective, as Steve notes, might it be prudent to just clearly state, what you have to do in these situations to avoid confusion? And I guess I'm more particularly concerned, so that's one issue. Then I'm also concerned about the current client situation. Do we sufficiently describe that with respect to the current client situation, that when you're advising and providing services away from the non-legal services, away from the legal services, the client's not going to benefit from attorney-client privilege, it won't be confidential, and that there are risks. And so those are my two big remaining concerns. But again, I guess it's mainly the remaining portion are more likely to be effective in certain circumstances.
In other words, I'm saying you have to say those three things, and you may have to do more for an unsophisticated client.
Well, and what would those be?
Among other things, it might be relevant whether on their dealing with you. You're going to
Okay,
have to do
well,
that anyway.
sure.
If it's a current client, right, unless they happen to stumble on you in some incredibly insane way, right? If current client and they're going to deal with your non-law business and you recommended it, there's almost certainly going to be 3.3A, 3.3, 1.8.1 compliance as well, right?
Okay. So
So you're going to have to say to them, that goes back part of the opinion. If you refer them to you, if you refer them from your lawyer business to your fiduciary business, that's going to trigger 3.3.
Sure.
I mean, 1.8.1, and they're going to have to full disclosure, go get yourself a lawyer, so forth and so on. All that's
Sure.
going to be built in.
So I just raised my concern that I don't think it's, if the consensus of the group is that it's clear and it's client protective, of course, that's within your ability to determine. I just raised that, it's of concern to me.
You have specific proposals for how it could be changed, other than the bullet points, which you've already worked through? Or you just disagree with the conclusion?
I think it would, well, I think bullet points would help. I think stating, because it's a new approach to this area, I think being as clear and, I don't want to use the word pedantic, as hand-holding as possible, would be enormously beneficial. This is what you need to do with people in a non-legal business. This is what we need to do with law-related services. So we need to do in fiduciary services. That's what we need to do with current clients. And as well as, you know, yes, what needs to be disclaimed? I mean, the rules of court, you know, the guidance that are included in the rules of court from the committee appendix, which I agree are mainly the 3 points that Steve has included here, are helpful in putting, you know, these people on notice. And I think of the concerns and restrictions that are gonna apply. So.
Apart from the fact that they aren't really very analytical and aren't very highly case law, but apart from that, those rules apply to people who are actually within our version would not qualify, right? If you're giving advice to people, if you're giving any legal advice to people, you don't qualify. We've made that clear at the outset. These people who are in court, right, they're giving legal advice to people all the time. It's like a totally different scenario. We've already said here, if you're giving any legal advice, well, you can't. This is those court rules really have nothing to do with it.
Okay, I mean, I would just again say for the point, it's notwithstanding the fact that you're disclosing, you're not acting as anyone's lawyer,
And you're not giving legal advice.
the court says, you know, the rules still apply. So that's the point
Well, the court,
I'm raising.
there's a whole big discussion of that.
Okay. And then, secondly, the law-related services, you know, do we need to, in a bullet point format, show how one might achieve distinctness? Those would be the other points, the only other substantive comment I had that I don't think was responded to. But we don't have to jump to that. Again, I don't feel great being the person that's like throwing sand in the gears. I think everyone knows I do have concerns, but just trying to be as precise and limited in my comments as possible. It was that paragraph that Dina referenced that also has concerns, but that's all.
wants to show us some proposed.
Okay, Mimi, if you can
changes.
Q 16003, then we can go forward. Okay, so over lunch, I had a chance, first of all, to look at Drew's point about Rule 8.4. This is a little embarrassing to confess to our national television audience, but I don't think that I had quite described Rule 8.4 accurately. And I think that we have now done a better job, Drew, with Drew's help, right? So what I had said in the earlier draft was that Rule 8.4 applied by its own terms, right? And then I quoted the comment to the rule, which actually is not, of course, the terms of the rule. And in addition, doesn't actually say that these things, doesn't say, it says this rule may or may not apply. So it was not accurate. So here's an effort to be more accurate. In addition, certain provisions of Rule 8.4 clearly apply by their own terms to conduct outside the practice of law. And I wrote down some examples without taking a view on whether all of them do. CEG, commission of certain criminal acts. That's 8.4B. 8.4C, dishonesty, and 8.4D, conduct prejudicial to the administration of justice. And it seemed to me that's a more accurate way, and I took the reference to the comment out. It may be that all of the provisions of Rule 8.4 apply, except 8.4A doesn't seem to, right? Because it's expressly premised on the violation of the professional rules, and that's exactly the issue we're trying to deal with, right? So I'm sorry for that error, and I hope that corrects the language accurately. Then I moved the reference to Rule 8.4 comment down to follow the reference to the comment in Rule 1.0, right? Because the language is exactly the same in both places, right? So that's number one.
Maybe we don't take it a parenthetical and we just make it and RPC 8.4. Looks weird.
Anyway, that's the first change. The second change, the other two changes are in to try and continue to address Dina's point. And if you go to 195, I believe it's 195.
Yes.
That's it, there it is. This sentence has been changed, right? And it's been changed in two ways. So it reads, the question rates where the application of the rules of professional conduct, and now I've put in the words following the changes, governing the practice of law. So it's the rules of professional conduct governing the practice of law. To law-related non-legal services automatic or inescapable, or instead can be avoided through appropriate clarifying measures that eliminate the reasons for applying those rules. And the idea is not to be too defensive about the term avoid. Originally, I had thought we would want to put in a footnote that say, well, we don't really mean avoid. Right? But that seems like we're protesting too much, right? Better to say, look, what we're doing is we're saying that where the reason for applying the rules doesn't apply, they don't apply, right? And so that's the second change. And the third change is at 488. And the whole sentence, that's not it, is it? It's 480. It's right in the conclusion.
Yeah, this is it's just
Right.
cleaned it up so the line numbers are different.
Oh.
Clean instead of red lines. So
Oh, okay.
that's fine.
All right. So a lawyer. So then the changes is actually in the. It's at the end of line 444. I added the words, it says rules of professional conduct, I added the words applicable in the practice of law. Right, so in each case, we're making it clear that we're talking about being able to step away from those rules, right, and not necessarily stepping away from all rules. And those are the changes that, those were the lunch changes, so.
I thought on that one that applicable to the practice of law was gonna be under the next sentence, which says, even when the non-law business is law-related in the sense, however, the application,
Well, I'm happy with that, if you want to move it to there.
Yeah, because it doesn't, you don't need the qualifier where, in the first, because all the rules apply.
that govern the practice of law or something like that can be avoided.
See, in the first situation, we're saying all the rules apply because the business is law-related and,
Okay.
and it's not sufficiently.
Right.
Application of the rules that govern the practice of law.
Governing the practice of law. Thank you that's a better language. And that's all I've got. So with that, I would turn it over to the committee.
Question on this. I'm trying to think of ideas that where we could remove the word avoid, and so let me propose something, and then you can tell me why it's bad, or maybe even feasible. What about, for instance, where did it go? Okay, so this starting here, this 498. Even when a non-law business is law-related in this sense, however. The rules governing the practice of law do not apply, or something like, what does the do not apply work rather than saying can be avoided?
I like that. Why not to say that?
And I'm thinking sort of globally, because I had the same reaction to the word avoided, and I'm concerned some layman might see that word as well and kind of run with and say, whoa, look, this ethics committee is trying to tell lawyers how they can avoid their duties. Obviously, that's not what we're doing here. But if there's a way where we can simply say something like the rules governing the practice of law do not apply where
I think it's great
globally.
to make that. Let me say, I think that's a great change to make there. I don't think we should try to make it globally at this point because it comes up at a number of places in the opinion. And I'm a little concerned that I think it's important to get this opinion out into the mix with the task force report coming, and get the, let people come back if they're concerned with that. We can think about how to tinker with the language throughout the whole opinion. But I don't think we should wait another month because it's been, we waited a month just to write a conclusion, right? Even though it turns out that there are a lot of opinions that don't have conclusions. Mm-hmm. If we wait another, when's our next meeting? I think we kind of missed the moment. So I wouldn't do it. I wouldn't try to make that change throughout.
Well,
but I hear your point. I mean, I think that it's a balance of considerations, and the committee could obviously decide differently. But I wouldn't want to miss the opportunity to get that opinion out and into the conversation.
Yeah, I guess it depends on how many times the word avoid shows up.
It's a fair amount, and it is true that the difference between, I don't have a problem with that.
I don't think, hold on, sorry, I don't think you want to leave out that conclusion, yeah. Okay. Sorry.
So I was going to say, there is a reason, even though none of us are totally satisfied with can be avoided, which comes up a lot, it isn't, it does need to be an active, imply action by the lawyer, because this is the exact thing. It's like, they apply unless you do a lot of things. That's what this whole opinion is saying. So we need something, I mean, it's fine here, do not apply, but generally we need something like can be avoided, like can be eliminated, can be, because you have to do something. It's not just like they self-executingly do not apply.
I agree with that. And also, I mean, to your point, we even now have in the language about presumptively, right? That
Yeah.
came in within the last one or two drafts, and that's right up front at the beginning. So, I mean, I understand the sensitivity of the word, but I think Amy's right. I mean, there's a presumption against you. There's a presumption that they apply unless you actively do certain things in certain situations in which they'll be avoided or they won't apply.
Right now, it
So
doesn't work.
we would say do not apply if the non-lawyer business is conducted in a manner distinct, right? Would they still get?
Yeah.
Yes.
Yes.
Yeah.
Yes. So, so we take away, right, that's exactly how it should be.
Yeah. Yeah. I mean, that's good for a summary.
And I think the basic point, if we were drafting again from the start, we might have to find other occasions where we could rework that language. But I would hesitate, I don't know, when's our next meeting?
June, but it has been,
So
we've
it's
had a,
it would be 2 more months. And I think as a matter of sort of public policy, we want to get this out and start getting it discussed in the framework of the task force work that's going on and so forth and so on. This is really a bubbling area.
yeah, we're gonna get comments, so it's almost, it's very unlikely that we'll be able to, after the comments, that we won't have to rewrite and recirculate, so. Okay, anyone else have anything last before I ask for motion?
So I have a problem with the 8.4 reference.
Okay,
I think A still applies because it also includes assisting, soliciting, or inducing another to do so.
I didn't say that, I did not say that, oh, I see what you're saying.
So instead of limiting it to the list, can we just say generally 8.4 applies? Instead of saying C, B, C, D, and, by excluding the others as an inference that they may not apply. I appreciate your general correction, but.
Okay,
I mean,
so you want to say just rule 8.4?
Doesn't say that, I think 8.4
Okay, how about this?
does apply. I see your terms.
Well,
I see
so
your point,
what if we added 8.4, assisting the violation in the violation of professional rules? I don't have a problem. If you want to say Rule 8.4 clearly applies by its own terms, but that's not quite accurate either, because the comment of the rule says sometimes it will apply and sometimes it won't.
Right, the comment says a violation of this rule can occur. Doesn't say will occur. Can occur when a lawyer's acting in these 3 scenarios. And I think the can is predicated on whether they do any of the things under A through F.
I think that's probably true, but it is confusing to think about how the first part of 8.4a, what that means. So we're saying the rules don't apply if you do all sorts of disclaiming and distinguishing, but it would still be professional misconduct to violate the rules?
Well, do we think, I guess that's a question, I mean, do we think if I disclaim, I'm not acting as a lawyer in matter X, but I somehow still assist, solicit, or induce someone else, or through another person to violate the rules, can we not envision a situation in which I still might be susceptible
Oh,
to
yeah,
8.4a violation?
the second half of A fits.
The
first
second
half
half of A
doesn't.
clearly does fit.
Right.
So I agree with you, but
I
it's,
wouldn't want to say.
no, I think that's fine. I don't know. I would think we could just say 8.4 still applies.
Okay, right.
I mean, I just, exactly.
Yeah, okay, that's good.
Certain provisions, right?
I
Yeah,
think,
say certain provisions.
What are you gonna start out?
take C,
Yeah, all the CEG,
All the
just leave
CEGs.
that whole thing out.
You could just drop a footnote and have a text of 8.4 if you want.
I don't know what the phrase by their own terms means.
Okay, well,
I'll
should it
just say
clearly
rule
apply?
8.4 applies.
Conduct, yeah.
8.4 remains applicable, conduct outside the practice of law.
Apply, just apply.
applies, just say applies.
The conduct outside of the practice of law.
Yeah.
Just take out the words by their own terms.
Yeah, okay.
Thank you.
There we go. I think we'll just leave it like that. Let everyone else figure it out.
Okay. Is there a motion with respect to this opinion?
I move to vote this opinion out for public comment.
Second.
Great.
We have to take a vote.
That's fine. I think it's a good idea.
Okay, so the motion is to circulate this for public comment.
Yeah.
Amy,
Yes.
Stephen,
Yes.
Kendra, David,
Yes.
Eric, Andrew, oh no, Andrew can't vote, Justin,
Yes.
Matt,
Yes.
Toby, Adam, Amber, Dina,
Yes.
Teresa, Richard, Stephen, and Marshall.
Yes.
Thank you.
Yay. Love that. All right. Let's talk, hang on, let me just look at what we've got on our agenda today.
I haven't said anything about dinner.
Right, thank you, Steve. So, anyone who
Social
is,
secretary here.
anyone who is who is staying in LA tonight, either because of the symposium or because you live here, we have dinner reservations for 16 for anyone who wants to come. Are there people who think who want to come? Matt?
Want to come
Will come.
I'd love to go, but I'm way back.
Fine. Anyone? Yes, no. Oh, too bad. I don't know, what time is it?
The reservation's at 6:30, but it's obviously flexible. It's 445 South Figueroa.
Well, okay. It'll be,
I would.
okay. Great. All right, so anyway,
We'll get a smaller cake.
yeah. And we'll drink more margaritas. Yeah, we just should have announced it earlier. It was all Steve's organizing. All right, so I think that we should do the 17001, the advising a marijuana business. It's too bad that Kendra's not here. Did you guys have a conversation about that, Steve?
We did not. I'm very disappointed in that. But,
Well,
so,
nonetheless, we should talk about it.
right, we should, well, I won't take a lot of time to, I won't take a lot of time. There were Kendra's comments, particularly her comments at the last meeting, were incredibly helpful. And of course, she has been the driving force behind our contacts with the cannabis community. I said the answer, the textual answer was clear on the question of assisting, which I think we all agree is the hardest question. And she said basically she had to laugh when she read that. And so my main goal in redrafting the opinion was to try and be clearer on why we think assisting works. If there's a move there that everyone should want to think about, it has to do with the way that I textualized the comment. And this is at 239, the discussion that begins at comment 239 of assistance, right? And what I did here is I took something that people have worried might be an actual bad thing, right? Because you remember the language of the rule that went to the Supreme Court was essentially that you could assist in any conduct that you reasonably believed to be lawful, right? And when that language was taken out and this other language about interpreting or complying with California laws was put in, the cannabis bar went crazy, essentially because they said, well, now look, we don't have a safe harbor anymore, right? And the argument here is, well, maybe the Supreme Court had something else in mind, which was an even broader safe harbor, right? Because it doesn't say California laws that conflict, right? It doesn't say California marijuana laws. It says you can assist in complying with California laws straight out. So why not just say that that textual argument lets you assist with, say, a commercial contract, right? Or a real estate lease, or whatever else you might need to assist with. That argument hadn't occurred to me before, but it seems to me we can make it true in some ways, in a way that would be helpful to people. I think that's the result we want, right? I think it is textually supported. It clearly seems to me right as a matter of policy, because it would be very weird to say you can assist in interpreting or complying with the marijuana laws, but once you've figured out what compliance is, you can't actually run your business. And so that's actually, I think, the most important thing in this new draft, other than, I hope, greater clarity and flow. So I don't want to spend a lot more time. I think it's much more productive to get your comments.
Cool. So let me see who's on the subcommittee. All right. Just for kicks this time, let's start with the subcommittee. Kendra's not here, so Drew or Matt, you're the representing members of the subcommittee.
Sure. So I thought it was a great rewrite. I think some of the comments that were made at the last meeting, and I forget the exact place, but I think Amy and I had both stumbled at a certain point when we got to the assisting part. I think it makes a lot more sense to me now. I do have to say, to the point that you just made, Steve, when I read this, I put in the border, I put clever. and I guess I'm not disagreeing with you. Everything you said makes sense. Whether that was the thinking of the Supreme Court or not, I'm not sure. But anyway, I just thought it was a great rewrite. I mean, I think it does a job of explaining, especially on the assistance, and it has some rationale there that we just didn't have before. One thing that struck me, let me just see my notes here, but moving back for a second to the advice section, if you look at 253, and this is just sort of for myself conceptually, but in understanding it, but you look at 253, talking about, at the same time, permission to give compliance advice with respect to California law does not extend to advice that encourages a violation of federal law.
Wait a second, I'm sorry, I'm not looking, I'm
I'm sorry.
looking at the clean. Are you at the red
Oh,
line?
yeah, I'm sorry, I'm on the red line.
Okay, let me move to the,
250, yeah.
sorry, so let me go move to the red line, because I probably should be working there. Okay. Well, but, I'm happy to work, okay, red line. At the same time, permission to give compliance advice does not extend to advice that encourages violence. Right, yeah?
Right, and so just making sure I understand, is this paragraph basically sort of saying the reason it's not expressly or tacitly encouraging the violation is because we're giving this kind of an accompanying disclosure that it could violate federal law, right? Is that the linchpin?
I think we're saying more than that.
Okay.
We may well be saying it does violate federal law. That's the suggestion.
Right, no, but what Drew's saying is, can you solve, I think what Drew's saying, so there is a way in which you could read this to say, our opinion says you can give compliance advice on California law, but you can't give advice that encourages violation of a federal law. Well, some of the conduct that you're giving advice on for compliance with.
I think that may not be the right language. We should, what's your sense, Drew, of how would you reframe it?
Well, I don't know. I was just trying to understand it. When I read it, it seemed to me that what we're getting at is that making the disclaimer about federal law somehow takes it out of encouragement.
That's what I'm saying.
And is that?
I think that's what I'm trying to that's my sense of how the rules work around the country.
Right.
Because virtually everybody who's written about this says you have to explain clearly, right, that this conduct violates federal law. And that and it is linked in a way. You can't do one without the other.
Right.
And that I think that's clear from the text of the comments more generally, of the rule more generally as well. But it is also and it's what the San Francisco and LA opinions say.
Right.
So whether the phrasing is exactly right, I don't know that the expressly or tacitly, right, is the right word, and maybe encourages isn't the right word.
Well, I just
We could say, for example, compliance that does not extend, does not permit the lawyer to, we could say, how should we say, does not permit the lawyer, I'm trying to say show due respect for, or something like that. But that's because I think that's the critical idea.
Yeah, and actually the way it came up in my reading this was I read that and I put a note and I said, I made a note to myself, so that, the linchpin is we're making this disclosure. And then later on when we talked about the business transaction, we kind of say it shouldn't be any different. And then I was sort of thinking, really, if encouraging is the trigger, I'm encouraging them, if I'm going to have an arrangement with them where I take a stake in this business, I'm encouraging them to move forward with this activity.
Okay, so let's go back to the, I'm interested in what the formulation might be. Does not permit the lawyer, right? It does not extend to ignoring, right? Or does it, what is the right?
That seems like along the right lines, the ignoring. I mean, I don't know what others think, but the reality is we can't completely work ourselves out of the fact that there is a conflict, right? So something that is legal in California is illegal under federal law, and you are helping someone do something that is illegal under another set framework of laws. So the place Drew has focused on in a way is the sort of knot of the issue. I think you've done a beautiful job articulating. I just wrote, here's my comment in the margins at that section. I just wrote, okay, yeah, that satisfies me. I didn't write clever. But anyway, so feels to me like maybe something like you can't ignore, you have to give due respect or something might be along the right lines. David?
Just some, a real-world perspective on this problem. I'm defending a lawyer now and convicted of structuring, financial structuring, advising a marijuana or cannabis client on bank transactions. Unfortunately, the client turned out to be a federal undercover officer, and there's certain reporting requirements for currency transactions, and $10,000 is a threshold to report. I haven't seen the transcript of the undercover. There's a recording of it somewhere out there. He pled to the felony structuring, so it's a pretty serious disciplinary matter. And I'm trying to understand the distinction between where exactly do you cross the line? If I say to you, the federal law says that you can't structure financial transactions to avoid the reporting requirements. That seems like that would be a permissible statement of what the federal law is. But I think what he did, and we're trying to get the exact language, he says something to the client like, be sure that you don't deposit more, don't deposit more than $10,000 because you'll trigger the currency reporting laws. So I'm trying to understand the distinction there between at what point are you telling the client and maybe you're telegraphing to the client what they have to do. Is that okay? And then you cross the line into saying, my advice is don't deposit more than $10,000 in cannabis money in your bank. I don't know if that's at all helpful.
Well, I think that first of all, so helpful to have a real life account. Second,
Well, we started talking about this opinion, this just
Second-
came in the door.
second,
Yeah.
I think that the problem there is that it raises the question of whether you'd be protected under this opinion because you're advising concealment, because what you're doing is doing something that could be argued to be intended to prevent the detection of the unlawful activity.
Right, and that's was the basis of his plea.
And that's the tricky part. I don't think we can, consistent with the way the California Supreme Court has talked about this, the way that the sort of weight of authority lies, we have to take a position against concealment, which is one of the reasons that I've said the duty of honesty may be different for lawyers in the marijuana area, right? And I think, but I don't know that. So that would be in addition compliant. So that would come in my view under 264 of the red line, right? Does not extend to advice about how to avoid detection of or to conceal a violation of California or federal criminal law.
Okay.
Right?
Maybe one of the ways to frame it going forward, Steve, is think of it in terms of a disclaimer, like you have a right to remain silent. In other words, if you put it at the front of a conversation, you're talking about what fractions of what part of your duty in a single conversation. What are your duties within that conversation? And those issues may not be that distinct. One of the things that you can do is you think of this opinion in terms of a disclaimer that somebody advising a client who's considering or is engaged in the cultivation of marijuana or a marijuana-related business. What would be the formula of alerting them that you're about?
Right. I think that the way the practicing lawyers, the ones who were most persuasive to me, said, I just say it over and over and over again until they get it.
Right.
That it's a federal felony. I'm wondering if the concern that's just been raised about this specific language that Drew raised, if we could simply say, rather than at 253, right? I mean, if you could put that up where everyone can see it. If we just say at the same time, right? and then jump to 255 and just say, at the same time, any advice that the lawyer gives about California law must be accompanied by clear and explicit information,
Yes, I think we should delete
Right.
that sentence, yeah.
right? Just do it, just say it
Just
without
say it.
trying to
Because your
explain what it
comment
is.
about tacit encouragement is in 261, and I think that's more in the context of that conversation where you're saying, like, if you don't explain all these things, it may be perceived
Right.
that you're suggesting that it's okay to do this.
Right.
When you're not really passing judgment on it, you're just giving the advice.
Right, I think that taking that language out actually addresses the, I think Drew is, I had anxiety about those words when I wrote them, but I didn't know why. I'm glad to have been corrected.
Microphone?
Yeah.
Drew, do you have more before we come in?
I mean, actually, that was the major one. I just have a lot of yes and
Okay.
very good.
Yeah, that's
And
great. Yeah.
Only one clever.
Yeah, it's beyond clever. I'm going to say that. It's persuasive, and I think it's the result that it's the correct result, and it has to be for lawyers practicing in California. Otherwise, again, you'd have the really ironic, anomalous situation where the people in California want this to be a major viable business in our state, but lawyers, however, cannot really help them achieve the goal that the people announce. So that's all correct. So I only had a couple things, I think. Two easy ones. One is, so the statement of facts says that, I'm sorry, I'm looking at the clean copy, line 54. The client wants advice and assistance about various things: business formation, financing, supply chain contracts, real estate, employment law, and taxation. So this, and then I read the rest of it waiting for and I saw what the restatement said, which is great, because assistance can include drafting and negotiating. It cleared that up. But where do you say that all this assistance that we're going to give, which is really like advice under the restatement, that will allow you to draft and negotiate contracts for the client? I didn't see, because that's what people, where's the payoff on that point? And I apologize if it's there.
I thought I had it, but let me just see if I can find it.
What line is it?
I think it's in this, it's in the language that says, application to hypothetical facts.
Yeah, I read that. Let's see.
At 424.
Let me look at the red line. 425?
Yep, it starts there. In the red line, it's at page 119 of the materials. The lawyer may also provide such advice and assistance in interpreting any other relevant California law, including generally applicable laws relating to entity formation, contracting, real estate, employment, and taxation. Accordingly, the lawyer may both advise and assist the client in obtaining regulatory improvements and taking all the steps reasonably required to make the business functional and profitable.
So I didn't misread it. Where does it? I get all that. You can advise and assist, and I can go read what the restatement says that means, and I can read, I think, at least one bar association. But why don't you just say that can include drafting and negotiating?
All right, sure. I don't have a problem with that. If you think that, if folks think that.
If I were a practicing lawyer, I think I'd like that clarity.
Including but not limited to drafting.
Yeah.
Right. But I'd say reasonably required, including, or, no, I'm not quite sure where to put it, Matt. Where would you put it?
I put it on the end of line 429, just advice is, you can tie it back to the restatement if you wish.
Yes, well, we could say,
Because the restatement's pretty good. I just flat out say, as stated, as discussed, make a reference to the restatement. Such advice and assistance may include, what does the restatement say? So the restatement is a pretty impressive authoritative body, I think. What exactly does it say? That's under counseling and advice under,
I'm looking at that language and thinking about it.
right, it's at lines 223 to 225. Preparing documents, drafting, negotiating.
Now, how about this? In obtaining regulatory approval in, among other things, I'm going to say, accordingly, both advise and assist the client in, among other things, right? Obtaining regulatory approvals, that could be drafting, right?
Yeah.
And negotiation, right? Comma, and all other steps, right? Okay?
Yes.
Now that makes sense. Mimi, do you have that? Or does that not win, is that not a winner?
I think it's good, but so can we apply that to David's client
I think they-
situation?
I think that's the issue, right? The concealment issue is whether we're overstating it if we don't highlight the concealment issue there.
Right, and also, what's the difference between saying, you should know that under federal law, if you put in $10,000 at a time, there's a reporting requirement. And that's it, right? Aren't you telling them, so put in 9,000 at a time?
Well, that's my point, is that at what point,
Yeah.
I mean, when you tell them, well, federal law says you can't do this.
Right.
And did he cross the line when he said, be sure you don't put in more than 50,000? Was that the statement that at that point
Right, I mean, even
moved
that's,
it over the needle over the line?
right, I guess that's right, but it seems really subtle to me.
It's always subtle.
It's
That
extremely
issue's all, but there's, I mean, how to put this? I'm not sure this is a distinct, marijuana is more the motivation here, right, than it is the
Right.
you know, in terms of the felony conviction that this person faced, right? It's it provides the motive to conceal, right? It seems clear, this is, you know, there's this language that we keep talking about it's in our rules now that didn't used to be, about the critical distinction between basically telling a client what their legal rights are and telling them how to commit a crime.
Yeah.
Right?
I'm glad
And
they
of
didn't
course,
say
that
clear
critical
distinction.
distinction is gossamer thin.
Right.
In reality, in a lot of situations, right? It's a critical distinction, but it's also a hard one to draw. And I think that, I don't think we're gonna solve that problem here, right? Because, I
It's
just,
B1.
what?
It's B1, right? What Amy said is,
Well, what's the difference between B1 and comment 1?
if, under B1, if you say, if you put more than $10,000 in there, this is the legal consequence of your action.
Yeah.
This
Right.
is what'll happen, which is different. It is, anybody with half a brain is gonna understand what you're telling them.
Well, you're
But
telling
under
them.
B1, you're telling them, this is what happens if you do that. Under what David's client may have said, you're telling them, don't do that, which is now providing legal advice to conceal, arguably. Not that that's,
Yeah.
right? But there's a difference. It's gonna be understood the same way.
Right. And he
Well,
actually-
no, yeah, exactly, sorry.
There's no essential difference though between those two in practice. Okay, he was convicted of conspiring to
Right.
violate the structuring laws. And conspiring with the undercover officer.
I've been in arguments with friends and colleagues about this issue for about 30 years. The real answer is that the way the rules are drafted allows you to give advice and not be punished if you have a smart client. But if you have a dumb client, and you spell it out, then you can get thrown in jail. And either way, the lawyer can be thrown in jail if the client lies about what was said to them, which is often the case, right? That's part of the danger here is that clients turn on lawyers in these situations when they're caught for doing something. So but I don't know that I really think if we try to solve that problem in this opinion, we'll go nuts.
We can.
So, okay, other than
Do you
that
need that
issue,
sentence still?
I think that the addition that Matt proposed is a good one.
I do too.
And shall I propose language or have?
Well, did you like what I had? Or do you have that? Go ahead.
I failed to listen close enough to remember what you
Can you
had.
say it again?
What I wrote is.
223, right?
Yes.
223 in the.
No.
In application
It's 426 to 7. These high line counts make me nervous, but in any event, 420.
Because of the red line.
Okay.
Yeah, I'd like to
Don't
think.
get so stressed out.
Okay, 426.
Right?
Line 5,200.
Exactly. Failed again. Okay, 427. Right? You see it there? Right? May both advise and assist the client in, comma, among other things, obtaining regulatory approvals, blah, 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 to marijuana business. At the after business, put comma, drafting and negotiation, comma, and negotiation. And then I would just say, and other steps reasonably required.
To make that business functional and profitable.
That's what I've got. Do you have a problem with that?
Why profitable? I mean, why?
Functional. How about functional?
I don't know about profitable.
Okay.
It's not your job to make sure they make money.
No. Well, it is actually. If you can't, I mean,
But you know what I'm saying.
if you're a business lawyer, your job is to help your client make money.
Okay. Matt, did you have other things?
I was wondering about line 488. Why is it merely preferable at the outset that you disclose?
I think it's Shabbat at the outset.
Yeah, I
think
I
that's
would, I would
better.
get rid of preferable. I think it's
that's exactly right.
Yeah.
That was a bad choice of words.
No, it's not. It's just so people are gonna love this, particularly the marijuana industry. We'll have a ton of comments. How do you, though, I guess none of these authorities really do, they do dance around it, it is clever. How would you answer the question, well, I know what 6068 says. Why is none of the above? Doesn't it all assist in the violation of a federal law?
It does. It does. We are writing an opinion that says you cannot be disciplined under California professional ethics rules for conduct which complies with those rules. That's what we're saying.
But
there's no question that.
But couldn't you still be prosecuted?
Yes, you can, and we say so. That's the first thing we say in the opinion.
Yeah, but you couldn't be prosecuted under the Business and Professions Code. 6068 says you quote. I mean, you have to support U.S. law. You're facilitating someone in breaking federal law. Couldn't you still be prosecuted under state law by some crazy prosecutor?
Yes, and we say that too.
Oh, you do?
Yeah.
Okay.
I mean, we say that we're not, this opinion isn't binding on everybody.
A
This is
prosecutor would
our
never
view.
hold political office, but that.
We are providing comfort, but not definitive protection. And I think that's
Why
the
do we
most
have the
we can
power
say.
to say this? Why do we have the,
Because we're construing the ethical obligations of California lawyers under California law. That's what we do.
But I think the concern might be, are we giving people a false sense of security?
I don't
Lawyer
think we.
people.
Well, that's why, I'll tell you, I don't know whether we are, you have to answer that question for yourself. What we say here, right? This opinion does not address any issues of state or federal criminal law and is not binding on state or federal criminal law enforcement authorities, right? And we say later on that it's not binding. Our conclusion is our standard conclusion, which is that it isn't binding on anybody.
I saw that.
So it's not, it's totally not
Were
binding.
you worried that someone would think that we tried to bind them? But we don't think they'll be.
No, I think we're writing this for the benefit, well, I don't.
We don't want the user to think.
We don't want the user to think that this is anything
Through the
other
back door,
than,
yeah.
what this is a set of arguments to be presented to State Bar Disciplinary Council
Of any crime.
in the event that
Yeah.
State Bar Disciplinary
Felony crime?
Council
He's
makes.
on interim
This
suspension
is,
right now.
that's all it really is.
One conversation.
Yeah, I think that's.
That's all it
You're-
is.
You are saying that no one could, no, if I were in the marijuana business, a lawyer, and I were prosecuted under federal law for assisting,
Yep.
whatever, collusion,
Right.
I couldn't drag this opinion out and say, well, look at this opinion. I would say,
You could try, but I think the thrust of the Supreme Court case law is you would lose.
Yeah.
yeah, I'd say, well, all this tells you is that you aren't violating California
Professional ethics rules.
professional ethics rule. It
That's all
doesn't,
it says.
I guess it mitigates your criminal intent a bit, but.
It might. Jury might buy it,
Yeah.
right?
Some judges would buy it. Some judges would say, I understand the policy reasons. Like, California doesn't want a bunch of lawless businesses, and that's fair, but most judges
I think it
won't.
may well help on the criminal intent issue.
It could, and if it does, great, right? I
Yeah.
think that's a plus as a policy matter,
Maybe this
but
is.
that's
a-
not what we're saying.
Oh, I'm sorry.
Sorry,
Maybe one of the things we can address, which is going to be David's situation particularly, is you can be criminally prosecuted, but at the other end, what is the implication of a discipline for a discipline based on conviction, a
Massive
conviction referral?
fudge.
All right.
Massive fudge
Well,
here.
if fraud, now in
It
David's
is what it
case,
is.
he may have a conspiracy or fraud issue going on, but let's assume for the sake of argument that this person completely complied with whatever it is we're trying to communicate in this opinion. And they get convicted anyway, federally convicted. And what happens at the other end of it is exactly what's happened to David's client, and that is there's a conviction referral to the state bar. And the state bar has to consider, at that point, whether the person should be disciplined. Now, the person is probably sitting in prison, but the question is, should that person be disciplined for that?
I
And
think that.
maybe that's something we should expressly address, because that's what
I think it's a really good question. Let me just tell you my thinking about it. Which is, it's a really hard question, and it's a harder question than the one we've addressed in some ways, because if you actually have a federal conviction, right, and it's brought in, then there are two different kinds of issues at stake, it seems to me, and they're not really ethics issues, and they're not really addressed by the Supreme Court opinion, by the Supreme Court's rule. And the issue is what weight is to be given to a federal conviction, if it's a federal felony conviction, as compared to a state felony conviction. And one kind of argument would be the state bar doesn't have to honor the federal conviction because it's not a federal law. It'd be like an anti-commandeering argument, right? They say we don't have to enforce the federal conviction, but I think that argument is problematic, right? Because you can't discriminate between federal and state convictions in that way. There's a whole body of case law that says, you can't, And so my sense is that that's a much harder question, right? That it isn't answered by 1.21, that it isn't fundamentally a question of disciplinary law, it's a matter of federalism. And I'm frankly, I think we'd be getting out in front of ourselves by into an area we don't really understand by addressing it.
I don't agree. I think I think that's, personally, I think this is something that perhaps we need to talk about a little bit further as we get a little farther down the road in this opinion. But the question is literally what happens, or the second part of the question. First part of the question, of course, is how do you get in front of this and advise the client? But assuming for the sake of argument, because we've already told, we're already telling lawyers they can still be criminally prosecuted by the state or the feds. What happens on the other end of the conviction referral? And the reason why this is important is that once there is a conviction, that conviction is going to have to be referred to the state bar, and the state bar is going to have to do something with it from a disciplinary standpoint.
And my point is simply we don't have it's not within our jurisdiction or our tools it's really an issue. It seems to me it's an issue that's really outside of our bailiwick. Right? We don't. Where are we going to find the answer to that in the rules that govern the conduct of lawyers themselves?
I don't see what the answer could be, because you've got 6068A, which is one of the things they bottom discipline for criminal convictions on, your duty to follow law. And now we have new 8.4, what is it, C, criminal act. And I know the way that discipline folks think, any criminal act in their eyes, has an impact on your law license, because attorneys committing crimes lessens the prestige of the legal profession, or the public confidence in the legal profession. So when it comes to criminal acts, their universe is very broad. Almost any criminal misdemeanor or felony crime now is going to result in some discipline. And that's sort of an ethics issue, but it's not really this ethics issue.
Right.
That's going to take the state bar court or Supreme Court, somebody challenging that. It's going to take somebody getting a felony conviction and taking it to the state bar trial and seeing what happened. We can't. How are we going to decide what a prosecutor with the state bar is going to decide to do? And I mean, you could flag the issue if that's what you're saying.
I would think it'd be very fact specific, and I think OCTC appreciates having the prosecutorial discretion with respect to this specific issue. So if you had a situation in which the lawyer complied with Rule 1.2.1, Comment 6, and all the California laws, as Steve has so helpfully pointed out, and yet, I'm going to use the word technical, although it is a correct federal violation, and that got referred, I don't think it would be surprising or unlikely that OCTC would decline to prosecute that case. That being said, there might be situations in which a lawyer does all those very same things with respect to state law, but engage in something egregious with respect to federal law. And they would probably want the ability to still prosecute the lawyer. And so I take your point, Teresa. I mean, there's a difference between flagging that that's a risk, and I know the OCTC representative made the specific point as we were talking about Comment 6 of this rule, that the criminal referral is still an ability to prosecute someone notwithstanding this Comment 6. It's his view, and it'll be to be determined, but his view, that would be a prosecutorial discretion amongst the Office of Chief Trial Counsel. But I agree with the sense of the group. I don't know that we can resolve that. I would strongly recommend against either I know we're not suggesting tying the hands, but directing one result or the other. I think this opinion is doing a lot of heavy lifting as it is, and I would recommend not addressing the issue.
I have a question. Maybe, Steve, you've answered it in this opinion. Is there any value, and maybe we've done this, to footnote or comment that this opinion does not address the consequence of the U.S. Attorney's Office or some other federal agency prosecuting it to a crime, and what the state bar would do to the lawyer convicted of a crime? Because that's a separate grounds for disbarment and other discipline. And I think that's what Teresa and David were talking about. And as soon as I read this, I mean, the state bar is obviously in comment 6, specifically addressed a policy decision. They could have said it either way in the comment because the rule itself doesn't talk about this issue.
Right.
It doesn't say, oh, you can comply with state law and violate federal law. The rule doesn't say that. The comment suggests that. That's pretty risky.
I don't have an objection to that. I think that might be a fair point, right? We're not, I mean, we could put it up front, right, where we say this isn't binding on prosecutors, right? We can also say, and we're not addressing, we're not addressing what would happen if a prosecutor were to act.
Yeah, those are
right.
2 issues we're not addressing, I think,
Right.
should be
And,
clear at the front.
So Business and Profession Code 6101 says that conviction of a felony, and then the case law under it says conviction of a felony constitutes cause for disbarment, and then the case law that I'm just reading says
Moral truth.
that's a conclusive finding that there's cause to disbar or to suspend.
Well,
So,
that's what
right.
I don't know whether that would bind, that might be cause, but only the prosecutor can bring that charge.
Right. I'm just wondering if have there been situations in California proceedings against lawyers where the lawyer is convicted of a federal felony? That's conclusive. It's conclusively been found there's grounds to disbar you, and yet the state bar court or some authority says, you're right, but we elect not to impose any sanctions on you. Has that ever happened?
I don't know, but Andrew's point is that the prosecutor has raised the possibility that might happen in this type of
The
situation.
prosecutor in place today.
You raised the hypothetical, and if I had to guess, I would say no. But the question you pose avoids the obvious issue, which is we now have a rule which permits certain conduct, notwithstanding the fact that it might violate federal law. And so,
But that doesn't mitigate the Business and Professions Code. It doesn't do it. Business and Professions Code is an entirely independent.
Right.
That's an entirely.
I think we have to say that what we're doing. I don't think we should try to reconcile the conflict between a comment to the rule and the clear. We should just say this is not where we're going here. We're trying to read the rules in light of the comments.
Right.
We're not. We're not giving you a free pass or suggesting that you have a free pass in the event that a prosecutor comes after you.
And if we say,
especially not if you're convicted.
we should say that up front in the opinion,
Yeah.
so that people aren't misled into thinking, well, this means I can do certain things. And the criminal conviction referral process is almost automatic. It's mechanical and automatic. I mean, there's very little. If you read those statutes, 6101, it doesn't seem to give the prosecutor any discretion about filing the record of conviction. It implies that gets filed in every case. They exercise that discretion on first-time DUIs, even though it's not in the statute. But in no other category of crime have I seen them decline to file the record of a conviction.
Right. But again, in this situation, in the hypothetical we're envisioning, the lawyer complied with California law.
Right.
It is a violation of federal law, conceded, noted. Anyone who reads this and they don't take away from that, they got other problems.
Right.
And so all the examples you're referring to, David, and the questions you're posing, Matt, do not entertain the world we're under right now, which is comment 6 to rule 1.2.1, which permits certain activity under certain circumstances. And I do think that is an element which would lend itself to allowing a prosecutor, and again, just assuming the hypothetical situation where the lawyer was coloring inside the lines the whole time with respect to state law. Speaking for myself personally, I've never worked in OCTC. I don't know them very well. I do. They're great. They would not bring that disciplinary action. I think they would decline. Absent you know,
Does the state,
extra
bar-
circumstance.
does it, who does the state bar court answer to or report to?
Ultimately, the Supreme Court.
The Supreme Court has approved these rules.
Right. Well, but
Do
the
they approve
legislature
the
did
comments when they
BMT code.
approve the rules?
Maybe what we could address is the moral turpitude piece, because 6101 talks about a cause for disbarment or suspension for felony and misdemeanor involving moral turpitude. And perhaps this is the piece that we can address to give a little guidance. If a lawyer does comply with all the California rules and complies with and it does everything this opinion says it should do, the lawyer should do, would that constitute moral turpitude? That's,
We say that, we do address that.
okay.
We do address that with respect to the question of if there's no conviction. I wonder if it's enough to say, this has really been a helpful discussion, I wonder if it's enough to say at line 87 of the red line, right?
What line? I'm sorry.
Line 87 of the red line. Which is, see, it's, so it finishes with, it finishes with state or federal law enforcement authorities. Following that, nor does it address the effect of a conviction, right, in a state or federal court proceeding. Something like, I'm sorry, I ran out of words. In a state bar proceeding or something.
State bar
like
court
that.
proceeding.
Yeah, I think that's a good change.
That is.
State bar, right, exactly. That can help.
No, sorry.
Is that a comma or a period before nor? My grammar's not that great.
No, leave that in, it's all good. It's the effect of that conviction on a subsequent state bar
Oh,
proceeding.
in a subsequent state bar, right? Disciplinary proceeding. No, I mean, I'm not there, sorry. A conviction in a state or federal proceeding in a subsequent, right? State bar disciplinary proceeding.
Yeah, that's a good change.
It's not perfect.
We're
We're not sending it out today though, right? So, what, yeah. Yeah, but I think that's the kind of caveat, and I want to have a footnote to 6101 there, right? I think, right? And then that's a pretty good red flag, I think, for people.
Okay, I like that.
Do we need the first proceeding? Can we just say conviction in a state or federal court? Or
Of a
bias?
criminal conviction, we could say, right, in state or federal court. That's a further step along the way, Marshall. I'll look at it more.
I'm gonna use this in our defense.
Yeah, right.
Yeah.
You should.
I am.
You definitely should.
We need to get it out there. Quick. Yeah, quick. Get it published.
Can you use it when it goes out for public comment?
No, I can steal from it
With
liberally.
I'm sorry, I'm not sure where we are. On the screen, the language, this opinion does not address any issues of state or federal criminal law except as background for ethical analysis. Okay. So what about even with respect to the issue of professional discipline, our conclusions are not binding on the State Bar's Office of Chief Trial Counsel? Have we removed that?
No, it's at the back.
Well, I'll look at the next. What I'm asking is I feel like we're over disclaiming now. And I wonder if we could just take these points together in 2 or 3 sentences max. I'm a little worried that I'm looking at the clean, what begins at line 73 and carries over through 74 to 77. I wonder if that tone and tenor is, and the point we're conveying is also captured by some of the language we've just added. And I wonder if maybe we could just condense it in the next draft.
Well, we could, given the I think the only question is, I think that the first one that says we're not addressing issues of state or federal criminal law,
I think that's helpful.
and it's not binding on federal law enforcement authorities.
Period.
Period, that's important.
Yeah, I agree.
Then I think it's important to get in the point that Teresa has, say that we aren't, that it's very important to understand that the referral process is different, right?
That's fine.
If there's a conviction, so that's the second sentence.
Okay.
And then the third sentence is the only one that you could argue could come out, because.
Which is the third sentence you're referring to now? Even with respect?
Yes.
Yes,
Because at
I would take that out.
At 600 to 603, we have our standard disclaimer.
I would take that out.
Right, which says, yeah.
I think that's helpful.
Yeah.
Thank you.
We already have that. That's already included in our standard disclaimer at the end.
Yeah, and it should be clear. I mean, come on, and I don't want to take away from.
No, I agree with you.
It's like the bread and butter of this thing. People are gonna be like, "Oh, I can't use it now."
No, yeah, you're absolutely
Anyway,
right, Andrew. You're absolutely right. We don't want to be too defensive about this, right?
Can I make one comment?
Yeah.
Just briefly, in the very first thing with the issue, I was wondering if we should insert the word ethically, and may a lawyer ethically provide advice. I know it's in the digest, but I think it's kind of important.
I like ethically, absolutely.
Yeah, and then in the conclusion, it's the same issue. It's a California licensed lawyer is ethically permitted to advise and assist. I think that's important in light of all these distinctions we're talking about.
Right. At 591.
Do you have to ethically before advise or before permitted?
Ethically permitted. Perfect.
So, if it's okay, could I ask a question?
Yeah.
Hesitant to ask this question because I worry that it's going to reveal my ignorance. But if you look at lines 357 to 362, I'm in the clean. I just have a general question about how this works in practice. I know lawyers, and I'm sure you all in your practice do this all the time, assert attorney-client privilege in discovery motions. And you say things are not to be revealed because they're privileged. A ruling comes in that the privilege does not apply. In that situation, you provide the material, hypothetically speaking, right? You tell the client, we did our best, this is discovery, it's not privileged. Notwithstanding the fact that it might be quote-unquote confidential. Is that correct so far? So even when it comes to testifying, if I say, oh, I'm the lawyer, Mimi's my client, so I'm not going to testify, Your Honor, our conversation was privileged, file briefs, it's litigated, and say, actually, for whatever reason, that's not privileged, I can't think of the situation which it would not have been if it's just two of us talking. I'm compelled to testify in that hypothetical, or do I say, oh, sorry, guys, under my duty of confidentiality, the discovery rules, I always thought the discovery rules would trump you assert the privilege, confidentiality is a subpart of privilege, but when a ruling comes in that something is not quote-unquote privileged, the confidentiality rule does not prohibit or permit you to not reveal that information.
I'll tell you.
That's not clear.
I was going to say.
I don't think it's clear. Some people do.
I couldn't hear you.
Here, I think the answer, the sort of literal answer, would be that the California rules of professional conduct do not contain an exception for compliance with a court order. They should. They don't. And that's what creates the difficulty, because it creates a situation where, and it's not only where a lawyer might view themselves as obliged, right? And certainly certain lawyers might find it tactically useful to pretend that they were obliged, to insist. So I fudged it here by basically saying, look, it's not a resolved question, right? It poses a hard choice. I'm open to being shown that that's wrong, right? If that, Andrew, if we have authority that says clearly what a lawyer should do in that circumstance, I'm totally open to putting it in. But I don't know whether we want to open that issue up. It's like a whole opinion worth of stuff.
No, that's probably question 2 or 3 to follow. Is just my general question is what happens practically in the practice of law. I didn't
Lawyers
know
often comply,
certain
and sometimes don't.
So they sit in jail over contempt of court.
They can challenge it with the contempt of court.
Right. I'm all good with challenging.
Some lawyers do that. A partner in the firm
But let's
I
say you
used to
keep
be
losing.
when it was ordered to produce some documents in the United States versus IBM that he thought were privileged, took personal possession of them, was held in contempt and took a separate appeal to the Second Circuit.
Yeah, it's just like what they do with the media.
With what?
What they do with the media when a newspaper reporter won't disclose their source.
It's basically the same
They fight
idea.
the contempt.
Well, and then some of
And
these
that-
issues
what-
implicate who's gonna pay for that issue and when they're gonna stop along those lines. So that's kind of like you said, it could be a full separate issue and thorny issue about whether or not, do you have something in your fee agreement that says if this happens, which they probably should, then if you want me to continue to challenge, if I'm in order to produce these, but you want me to challenge these to, then the client would pay for that, or how would that? Because I think it's one of those questions that is often like, well, how far does the attorney need to go if they've been ordered by a court to do it? And, how they meet those obligations in light of a court order, right? And then to what extent do they need to sit in jail for a year? I'm sure most people would think they probably don't.
So are you
But-
proposing a
For some people, it
new
could be a
area for
marketing
opinion?
No,
I'm
Yeah.
the guy who'll go to jail
That's
for you.
right. Hey, actually,
I'm
this.
not proposing a new area for the opinion, but I'm just.
Right.
This makes me think, and maybe it's in here, but on this section we were just looking at, should we be citing the prior COPRAC opinion that dealt with the order from the court to disclose confidential information in connection with the motion to withdraw, which kind of presented the same scenario? Remember?
It's a good question. I don't know that opinion well enough to know whether that's a good thing to put in or not.
Yeah, I mean, I'd have to go back and look at it, but
Can you
conception.
shoot me the site and I'll
Sure,
look at it?
sure.
Yeah, because I think when you're talking about advising them of the risk that might not be, that the attorney-client privilege might be something that this court wouldn't recognize, that maybe that's part of the disclosure too, that like to what extent you continue to
Right.
maintain the privilege, and that would probably depend on conversations with the client about their feelings about that. And
I don't want to have this go too far off topic, but this is interesting. Is it still the case that in federal court, you will have an in-camera inspection of attorney-client communication, but you can't in state court, only as to work product?
Right.
I think that's correct.
So if a federal judge orders you to turn over confidential attorney-client communication, does the COPRAC decision address that?
COPRAC decision is dealing with state court.
Well,
I can't remember if
probably
it
wouldn't
make-
matter which
makes-
court it is.
Well, I'm sorry, so what's the question again?
Do we have an opinion that says if a court order tells you to turn over in camera?
No, my recollection is that the COPRAC opinion, I think, and I have to go back and look at it, but I think it makes the point that in state court, you can't, the court can't force in-camera disclosure. I think they mention that, and I think the end result is you're stuck in this kind of Hobson's choice, and the lawyer's gonna have to decide, whether they're gonna say it's a duty of confidentiality and I'm sticking by that, or if they're gonna comply with the court's order, and there's an analysis of the statutory provisions that talk about complying with a court order and so forth. And anyway, I mean, Steve's point's right, gotta go back and see if it makes sense to cite it, but I think it highlighted the tension that is referenced here anyway, so. And it's 2015-192, Steve.
Okay. Just before I got there.
That's interesting.
All right, so we,
Is there, I guess I want to play, the way this commentary is going, the suggestion is that the changes to the opinion are pretty minor. right, relatively speaking, but I want to make sure that there's nobody who has some other big concern, because if there is one, we should surface it. Because it would be, I think, this is one where the practitioners are screaming for,
Yes.
right? And so it'd be really nice to have it go out for review at the next meeting.
So
So any other thoughts?
Not a big, it's not a big concern. I just wonder, the last section, truthfulness to third parties. And I had a note, if an illustrative example would be helpful. I know not all of these have illustrative examples, so I'm happy to be told no, and can't think of one, and that's fine. I just thought for this issue, which is fairly thorny in my mind. So my note was, would an illustrative example be helpful? I think so. 3 underlines, all caps.
Big fudge. I don't want to.
Okay.
But I'm open to the idea that we should. I think what I wanted to do, this was an idea.
It's such a tough spot.
This really came out of discussions with practitioners. And we started talking about what happens if you can't get a bank or an insurance company or so forth and so on. You know, and and they basically said, we feel as though being in the business we're in, we have to be super truthful. And this is an effort to kind of suggest to practitioners that might be right, right? without trying to pin them down in any specific situation, but to invite them to be more forthright. Because I think that's actually, it's not so, I don't think it's important for state bar disciplinary purposes. I think it's important for not getting in trouble with the federal authorities, among other things. Anyway, that's my sense of it. It's more like putting a warning out there, that rather than putting any particular lawyer on the hook for any particular kind of statement.
I guess I didn't pause on this at all when I read it first, because I think that the advice seems solid, but I am now thinking, does 4.1B really, is that really the rule that's the hook here? I mean, when I think of 4.1B as like the Jones Day opinion, right? Like you, it's, you've said something, your client's not trying to hide something, some representation has been made, and so therefore, like, you have to reveal the rest so that the client doesn't defraud the other side, right?
Right.
Is that what? Yeah, but I think what you're talking about here is like, you got to tell the landlord when you're doing the rental agreement that your client's a marijuana business, because they might not want. And I don't think that's a 4.1B situation.
I didn't read it. I think it depends a little bit on what you think is concealment, right?
But the client's not committing a fraud. They're just, all the client wants to do is have their business operate in that building. They're not trying to pull one over on the landlord.
What, you think so?
No, I didn't think so. They're not going to pay rent, and they just.
They're being asked what type of business they do.
Well.
They say something like, it doesn't describe that they're a marijuana-related business. I think that's
okay,
problematic.
But okay.
Usually, commercial leases are going to ask what kind of business is being conducted, and I think that
all right.
attorney shouldn't be involved in, having a draft of a lease agreement back and forth where they're modifying provisions where it says that they're doing something that they clearly know they're not doing.
Fair enough. And I guess maybe that's the right way of.
The way I put it is, depending on the circumstances, including the expectations and situation of the third person, concealment of that fact may itself be a form of civil fraud. All right. And what I'm trying to do there is to capture the form of civil fraud where you know something really important about the situation, right? And the kind of thing that any normal moral person would normally disclose, right? And you don't disclose it. The example in the professional discipline context is your client has died,
right?
And there's discipline, for settling the case after your client has died without disclosing it, right? On the theory that that's just such an important fact. It feels like the fact that you're engaged in conduct that's a federal felony
Yeah.
might well be something that fits in that category. I don't want to say so, right? But I want lawyers to think about that.
I don't disagree, I'm just wondering if it's really a 4.1B.
It is because
Because of the
concealment, because liability for concealment under California state law is more than half truth. It goes further than half truth.
Assisting a criminal or fraudulent act by a client. So you can make the argument that it's criminal under federal law, right? And that's one
Right.
example or reading which would
Right.
make 4.1 be a criminal.
Or it could be fraudulent under state law, and that's why the
But that's only if
citation.
you were asked or required to reveal something, because, sometimes someone may not care. Maybe
That's why I
you
said
affirmatively share that information, would you be violating 4.1B?
it's pretty. Now I'm going to defend my drafting here a little bit. I have not said anything other than that. I think that anyone who's spent any time wrestling with the concealment under California law, right? It's tricky, right, and it's dangerous, and it's a trigger for what could be fraudulent activity here. I think this way I've written it deliberately just to flag the risk for people so that they can think about it. If their client is saying, for example, I'd rather not tell the landlord that, I want the lawyer to think about whether that could be assisting a fraud.
So
without
fraudulent-
telling them that, not saying that is.
So fraud is defined for purposes of the rules, and it means fraudulent under the law applicable in the jurisdiction, and I don't know it, if it hits all the
Factors I defer to you, and has a purpose to deceive. So if you're not being asked, I don't know.
California's got, the common law fraud in California is if it's material and you have reason to believe it's material to the other side, and you have reason to believe that they will not discover that fact, that's probably, I think isn't that fraudulent non-concealment even in the absence of, even the absence of a,
That's the kind of case I have in mind.
I think that's even fraud, even in the absence of a fiduciary duty, I think, so.
That's
So, but
exactly right.
your words are sufficiently circumscribed, that you're just flagging it as an issue for people to consider.
That's all I'm trying to do.
Yeah.
I want people to understand that their exposure could be significant, even in this simple non-disclosure case, right, where there's no actual duty to disclose, right? I want people to understand that because of the nature of this business, right, their duty could be broader and that they might want to practice that way.
Does the Supreme Court have any authority over our opinions?
Not directly.
I mean, can they say, thanks for the public comment, we order you not to publish this? I mean,
I like to think that they're counting on us to write an opinion like this.
because I was just thinking about is it 6101, to go back to that, I'll be brief. I looked at one of the cases, I just read it, in Ray Rothrock, which is the case is so fun to read. The question was whether a conviction of assault with a deadly weapon, which is presumptively, it is a conviction. It's grounds for disbarment, but not necessarily, not unless it involves a crime of moral turpitude. So, I mean, how could it be a crime of moral turpitude to do something that we believe that the people of California allow? And we've published this opinion. Supreme Court hasn't rejected it.
Okay, wait, David, I
Yeah.
see your wheels turning, but we're not gonna talk about referrals and state bar.
All right, well, anyway.
Any crime, even if it doesn't involve moral turpitude, can be subject.
Yeah, you can definitely you're subject to discipline, but it doesn't end the discussion. The Supreme Court would look at this opinion, would look at the California law and go, I get it, it's a felony under federal law, but it doesn't reflect negatively on the words in the Rothrock case and those that follow are really interesting. It talks about whether it reflects negatively on you as a lawyer and your ability to be known as an honest lawyer.
Who should cite that? I think, but it's relevant to our discussion.
I'll
of what
send you
would
the
happen-
case.
What should happen under the other sections of the business professions code.
I'm gonna send you the case right now. It's really interesting.
I just wonder in that, back to that section that Andrew pointed out, whether or not, like, why we're not also referring to 4.1A related to that. Just the general duty not to make false statements. I mean, I think it's kind of, you're just talking about truthfulness in general to third parties, and maybe that's an obvious thing that we don't need to say, but I mean, we could refer to it at some point. And then at the very end of that statement, there's a reference to 4.1 comment 5, and I noticed there's not a comment 5 to 4.1. And
Minor
so
detail.
I
I wonder who could have typed that, some idiot.
So I didn't know what comment maybe that we were specifically referring to. Maybe it's 3 or something, I don't know.
I'll look and see later. It's obviously a typo. So
Yeah, no, I know. I just
I don't know
wanted to
what it
raise
is.
it in case we were talking about voting
Right.
it out. I mean, I kind of think an example would be helpful there too, but I guess I understand your rationale for not wanting to make a specific example.
Well, I mean, we could think about it, you know. We could put it, an example might be the very simple one where the client doesn't want to explain to somebody with whom who has a material stake in the matter, like a landlord, exactly what they're going to be doing.
Yeah.
Now, maybe there's not, I don't know whether that's a realistic hypothetical, given the way that the regulations work, right? It might be that they just can't possibly do that consistent with the way the marijuana regulations work, and I don't know enough to know. So it might not be an interesting example, but I'll think more about it, and that's something we're getting back with our practitioner group, or some of our practitioner group next month, and that's a question I'll put to them too.
Great, okay. Let's see. So we're not going to do the laptop opinion because the lead drafter's not here. Sorry, let me get back to my table of contents or my agenda. Did that. So okay, let's do litigation funding and then do duty of confidentiality, and I think we'll get through everything. So lit funding is mine. Oh, absolutely. Is that time sensitive and that we need to do it today? Yeah.
Should we do that now?
Yeah. Thanks, Matt. We'll do it now.
We're doing 19.
Yeah. Who's the one, Steve, did you provide the?
It's his Andrews and my joint product.
Okay. Is it printed here or can you just have it? Yeah.
You know,
Of what?
Andrew, do you want to talk, or do you want me to, whichever you prefer?
Just the letter.
All right, so what we have here is the most, we have I won't go all through all the details, but the gist of it is that you have a statute that used to apply only to lawyers for persons. The first step is that it allows for post-conviction discovery, right? And the statute permitted it only in cases where a person was sentenced to death or life without parole. And now that right to obtain post-conviction discovery has been expanded to include cases where a person was convicted of a violent or serious felony and sentenced to 15 years or more in prison. So there's a broadening of the statutory right to discovery. And Section G of this statute says that trial counsel in a case involving such a felony is required to retain a copy of the former client's file for the term of his or her imprisonment. Now, one issue here is whether that language, right, for trial counsel, right, applies to prosecutors. And I don't think it does, because the language says trial prosecutor shall retain a copy of a former client's files. Prosecutors do not have a former client, right, unless they actually leave public practice, in which case they have a former client, but they no longer have access to the files, right? So that doesn't, for the term of his or her imprisonment, his or her is not a possessive pronoun that we would normally apply to the federal government. And that federal government can't be imprisoned, and neither can state government. So looks like that's just for criminal defense lawyers, right? And then we have this direction from the state bar, from the legislature, right, which says that we're supposed to study the issue of closed client file release and retention by defense attorneys and prosecutors in criminal cases, right? And we're trying to figure out whether the duties relating to release and retention upon the finality of a case of the termination are clear in light of the rules of professional conduct. And we're supposed to find that if the duties are not sufficiently apparent, we should consider issuing an advisory opinion. Or if we find that they're deficient, we should recommend a new rule. Okay, that's the gist of it. What's the existing law apart from this 15-year retention period for defense lawyers? Right. The existing law in a criminal case is, for a defense lawyer, is that there's nothing in the rules of professional conduct that says anything about a defense lawyer. In fact, there's nothing in the rules of professional conduct that says anything about any duty of how long you're supposed to retain files, right? The ethics opinions say that in criminal cases, and this is includes one of ours, that in criminal cases, and it does not distinguish in terms of the severity of the criminal offense, right? It says the lawyer shall retain the file for the lifetime of the client. So as written, it actually says that even in a misdemeanor case, you have to keep the files of your client for their lifetime, which strikes me as probably wrong. If you think about it, the rationale for that is you never know.
Bright line rule.
Yeah, it's a bright line rule, and you never know what could happen. Criminal cases are so important, anything could happen, right? So you better keep it forever. Okay, so that's one problem, is that we have this, our ethical rule is actually more stringent than the statute, vastly more stringent than the statute, right? So then you might well ask, why was the statute felt to be necessary? Right? Because obviously a lot of people don't know about the ethical rule. Part two is we haven't been able to find anything, Andrew and I haven't been able to find anything telling prosecutors how long they have to hold on to stuff, right? And indeed, if you look at the statute itself, right, Section F of this statute says, this section does not require the retention of any discoverable materials not otherwise required by law or court order. That would seem, right, in some weird sense, to give prosecutors a free pass, right? So that's the background in which we would be thinking about, do we think we should be writing an ethics opinion to clarify retention duties? If so, would we write it for defense lawyers, for prosecution lawyers? Or is what we'll be recommending is a new disciplinary rule with timing provisions, a comment to the rule, or maybe even legislative change. I'm not so sure we can. I'm not completely clear. Probably the Supreme Court can, but we'd want to reflect on what kind of file retention duties could be imposed on prosecutors by disciplinary rule. I'd want to think about that. Or whether it's wise to enforce by disciplinary rule. That's sort of the background. Andrew, other thoughts on this?
I think you stated it very well, and so I appreciate that. I think
It's really confusing.
we're just, well, to try to make it as simple as possible, there's a new statute, as Steve described very well, describing what a attorney's responsibility is with retaining criminal files for purposes of post-conviction discovery in cases where the person's been sentenced to 15 years or more. And as part of that, the drafting that legislation, the legislature has directed the state bar to study whether or not ethical obligations with respect to post-conviction discovery are sufficiently described. And I think the first place to look at would be at Rule 1.16. If we conclude it's not sufficiently described, and take a step back, in the legislative analysis, they are aware of the two ethics opinions we've shared. So they had that as their background as they were drafting this legislation. So we don't think 1.16 is sufficiently clear with respect to retention of criminal files for purposes of post-conviction discovery. What recommended changes would this group make? Change the black letter, change the comment, or issuing a ethics opinion? And as we make our recommendation, the typical approach when bringing these before the Board of Trustees and ultimately the Supreme Court, if it's a rule amendment or a comment change, is to state the pros and cons to any potential course of conduct.
I want to make sure I understand this. So this is the law now. I see there's a bright line on convictions of 15 years or more. So that's the law now. That applies to both criminal defense and prosecutors, right?
I don't think that language supports a reading that applies to prosecutors.
Trial counsel.
I thought so, but
Read on.
Oh, that's right. They don't have a client.
Wait, on the
Really?
client, and the client is not denominated as his or her,
So is that clear?
and the client, and the government client can't be imprisoned, so it's pretty hard to read it as a line.
Oh, gosh.
The other problem is it defines discovery materials as materials that are in the hands of the prosecutor, which
And then
seems
it
to
says
be in
they don't have
conflict.
to be preserved.
Right. Yeah, it says nothing about preservation.
It says they don't have, it
But-
says that no duty to preserve discovery materials is imposed under this statute. So unless there's a court order or some other provision that I'm not aware of, you wouldn't have any duty, the prosecutor doesn't have any duty under the statute to preserve. I think that's the way I read it.
so you're looking at F for that proposition?
But I think Teresa's first point is discovery materials,
I'm sorry.
she's absolutely right. Discovery materials are what the prosecutor has, right? And then the language goes on and says, this statute doesn't impose any obligation to preserve discovery materials. So it actually is more than just that language about the client only applies to criminal defendants. It's that the other language appears to take prosecutors completely off the hook.
Okay, well, I mean, that might be the reading, and I wasn't involved in how this statute came about. My general understanding from second and third hand knowledge is there's just been great concern over the years where the prosecutors are pointing the fingers at the criminal defense lawyer, and the criminal defense lawyer is pointing the finger at the prosecutor when the Innocence Project or any other subsequent defense attorney or interested party is making a post-conviction discovery request, and everybody said, oh, I don't have a file. And so, notwithstanding if the statute's less clear, I think as I read Section 3 of the Assembly Bill as well, I mean, It says, to study the issue of client file and release and retention by defense attorneys and prosecutors in criminal cases. That might be separate and apart from what the legislation says, but I would hope that they would want it to apply to both, but.
Well, I guess my feeling is that the directive certainly invites us to look at prosecutors. I'm just saying that the statute itself does not appear to impose any obligations on prosecutors that are of the kind that we're talking about. That is file preservation obligations.
It seems like that would be important, because if the legislature has implicitly made a determination that they don't want to impose that on prosecutors because of some kind of burden, then what are we doing, creating an ethics rule or a comment or an ethics opinion saying prosecutors have to keep the file for X years?
Yeah, does anyone know? I mean, this is an area where my knowledge is really deficient, but the language of the statute says, this section does not require the retention of any discovery materials not otherwise required by law or court order. A court order presumably is case-by-case thing, right? But if there are other obligations to preserve materials imposed by law on prosecutors, does anyone have idea whether there are? Because I don't know of any, but I'm not an expert at all in California criminal procedure. And this is a very specific kind of California criminal procedure question. So do we even know what the DA, do we have any idea what the practice of DAs around the state is? I'm guessing completely.
I don't know how we could begin to write this without having a criminal lawyer. We can go out and talk to criminal lawyers.
I kind of agree with that.
Yeah, this is important, but it's truly important, and we all know that the file retention, there's not very much at all. Where'd the 5-year thing come from? Is that in a COPRAC opinion? Where did that come from?
That's from an older opinion, an LA opinion.
Right.
It's a 5-year one.
Yeah.
What? Not the one I read. It said lifetime.
Just for general.
For general.
Oh, for general, right.
The LA is for the life of the client as well under.
In all matters?
No, criminal.
Right.
So both LA and, unless you return the file to the client or the client gives you permission to destroy the file.
Oh, right, they were talking about how the analogy for the 5 years was drawn by the obligation to preserve records related to client trusting acts and stuff for that period, and the analogy was drawn as that's reasonable.
All are statute of limitations. I'm not sure one or the other. I know it depends on the claim, but.
Oh, I thought it was related to IOLTA stuff, it was like 5 years, they extrapolated that analysis to provide the reasons on the basis that
Yeah.
retention for client files should be provided based on that.
I mean, if people are, well, they are, they're criminal convictions that are reversed 40 years later. Does that mean the duty of competency means that you should preserve files for every criminal client forever?
I've not read the COPRAC opinion, and I bet you that was part of the analysis.
Well, the COPRAC opinion says for civil cases, right, it says it's basically a rule of reason. The COPRAC opinion that we circulated, it's a rule of reason absent. And then for criminal cases, it's the lifetime. And
because of this potential for a reversal, though.
I mean, one question would be what would a rule? I mean, it's tricky to have a rule of reason analysis, right? In criminal cases, I think for a number of different reasons, and one is this anything can happen kind of thing, and bright line rule. But another argument in a criminal case would be actually, since there's no malpractice liability, and you getting rid of the files could actually insulate you from ineffective assistance of counsel claims. I mean, there are a variety of different arguments for imposing an absolute duty like that.
Well, I mean,
But we haven't, I don't know what.
But does the duty of competency include the requirement to maintain records of a former client?
of a form pertinent to a, I mean, logically, in the criminal context, you go, well, yeah.
The other area,
But
you know,
I get that literally the duty of competency survives the end of the attorney-client
with
relationship.
the other piece here, and I think it's
Is that true?
implicit in all files litigation these days. And it's for example, and in things like data breaches and so forth and so on, is that there's another theme, which is a property theme, which actually comes up in the LA opinion, but I've seen it now in other places too, that maybe the client files are property within the meaning of 1.15, so that they're subject to a safeguarding kind of obligation, and you can't destroy the client's property without permission.
But
And
that
so-
wouldn't apply to the attorney's work product, because there's cases that say.
It might. It depends. There's
Yeah.
there's case law going both ways on that.
Yeah.
There's case law that says the work product is also owned. This is, I mean, there's a mess. There's a whole messy area. I don't think we want to get too conceptual about this. We should ask ourselves.
I think we should
what the
narrow our
right, what's the
focus.
right rule for these kinds of cases, and then we'll figure out how to justify it in terms of whether it's property or what have you. But
Right, does Rule 1.16 talk about length of retention of any files other than criminal files? No.
it doesn't talk even about criminal files.
Exactly. So if if the assignment as directed by the legislative language.
But we have to be alert to the possibility that there's a reading that 1.15 could be read as protecting the files as well.
Sure, we could include that. That'd
And
be
I
very
think it's
helpful.
something to think about, because I've seen that's a serious argument.
So my, just speaking generally, rules are, as I understand them, to be written for general application for all lawyers, generally speaking. If there was consensus or agreement, outside the special duties of a prosecutor role. If there was general agreement with respect to that, I'm not sure a black letter change specific to just criminal attorneys or prosecutors. I mean, of course, you could do it. I don't know if it'd be warranted when you consider the general applicability of rules to all other people. Possibility might be raised. What does the exclusion of other lawyers mean with respect to the specific reference?
Andrew, what's the time frame? How fast do our masters need an answer by?
I mean, no time deadline was included. We should certainly do it as quickly and efficiently as we can. Continue to talk about it and move the ball down the field at each meeting. If we could have an answer by the end of the year, I think that would be great.
You know what my instinct is here? We should do first of all, it shouldn't be just you and me. This is a project that have more people involved. And my second instinct is we should go out and do some talking to people. And the place I would start is with the criminal post-conviction bar, right?
I would start with George Cardona. He's.
I was going to say
he was
Cardona
on
would
the
be a great person. Also, I was thinking
Rules
about who we
Revision
should talk to on the prosecutor's side.
Isn't
He's
there
not
the
a state court
Association of
prosecutor,
District
right?
Attorneys? I think there
He's
is.
a federal prosecutor.
No, yeah, and now he works, I think, for the city of Santa Monica.
Oh, he what?
I think he now works for the city of Santa Monica.
As their city council, or?
I'm not
their
sure.
city attorney? Well, he's absolutely terrific.
Yeah, he'd be
And
very
I think he'd be great to
helpful.
talk to about this. And I'd
But-
like to actually go to talk to the death penalty clinic people at Bold, because they're.
Or
they're-
Lori Levinson, she might have been involved.
Actually, the Innocence Project people would be great too.
Yeah,
I'm gonna talk to the death penalty people because they're my friends.
okay.
And I figure I can maybe and so we can start to get smarter about this.
Sure.
And then maybe report back a little bit on what do something like that. Do you want to talk to George?
Sure.
And I'll talk to these other people. And who else would like? Was there anyone else? Amy, do you think it makes sense to have someone else involved in this project?
Yeah, I do.
So, any volunteers?
Is this really to report on whether we think we should be drafting an opinion, or is
it's not actually a draft.
I think we're actually gonna find out what the state of the world is first.
Yeah.
And that's project number one, and then,
So it's to answer the question of whether we think there ought to be an
yeah,
opinion, not to draft an opinion.
So, right, I mean,
Right.
what-
You just want to know what you're getting into.
yeah.
The conversation has been great and is helpful. I don't think we need to make it wider than is necessary. The assignment, we should be asking all these questions. I'm not saying otherwise. I'm cautioning us to be careful.
So what is
the
our
rule
assignment?
sufficiently direct and explicit? Be a yes or no question. I think the answer is no.
Okay.
Right.
With that in mind, what recommendations do we have? We modify the rule itself, draft an entirely new rule, add a comment to the rule, or issue an ethics opinion.
I
Could
think
be a
I-
combination of the two. You know, many times there are comments that refer to existing statutes for further clarity about legal obligations that are associated with a duty stated in a rule. I think that's a possible result. And we could also issue an ethics opinion to be more fulsome in state the obligation.
We need to understand criminal procedure.
We really
This
need-
is a duty to retain file. You don't-
Well, to know what your
The
duty is.
statute is imposing a duty
No,
So is that duty sufficiently clear within the rule is what the assignment is? You don't,
No, but the
No,
statute,
I'm not disputing that, I'm just saying that to ultimately draft an opinion, if that's what we do,
Yes,
we
agreed.
need to understand criminal procedure.
I would agree, I'm sorry.
I guess,
Criminal appellate procedure, too.
Yes, and that would take time, that would be on a separate.
well, I guess I don't want to, I want to find out just how some smart lawyers think about this stuff and what the actual practice in the field is a little bit, because I just don't have any idea what people actually do. Right? Or how they conceive of their obligations, right? Or what they think the holes are, like the perspective in terms of how long things should be retained and so forth and so on.
Are you talking with respect to drafting an ethics opinion?
I'm talking about what we're trying to figure. I mean, I think what form the change might take depends very importantly on what we're trying to do.
Sure.
The bigger the change, right? The bigger the change, the more likely you need something beyond an ethics opinion. You don't want to try to carry a lot of water with an ethics opinion.
Right.
If what you're advocating is a really significant change in practice.
You know, one of the things is, as long as you're talking to some of these people, is to ask a very simple question, which is, what is this law trying to do? If you were to look at just the first section, all it's trying to do is to increase access increase access by convicted person by lowering the threshold a little bit in terms of what they're allowed to discover. That's what the first paragraph says it's trying to do. And yet, if you read the rest of the law, it looks as if, A, it requires the prosecutor to do nothing, and B, it requires the defense to retain a file. Well, another reading is that paragraph A was all they're trying to do, because there are two things that can impede that particular purpose. One of them is if the prosecutors didn't retain the file, and there's a legitimate reasoning that this whole thing is about prosecutors retaining a file. Rather than giving them free right, there's another way to read it, is that this law does apply to prosecutors, implies it wants to make sure these materials are available, and it doesn't require, if there's any other order or law that says it's not discoverable, then that's okay. But this one says it is discoverable. Then the second thing is, the other thing that can impede a post-conviction relief would be if the trial counsel for the defense didn't retain his or her file. And perhaps that's the other danger they're trying to address for the first time. And that is not only the prosecutors want to make sure they retain the file, but also to maintain as a resource the defense file. And so I think a simple question to help us iron out whether there's inconsistency within the statute is to ask the question, what are you trying to do? What were you trying to do? And any of these people can tell us what this is trying to do. in the first place. And that will tell us if there's an inconsistency in how they're trying to do it.
When you say any of these people, I mean, I think, I
But
understand
I'm
Lori
saying that-
Levinson would be a good person to talk to,
Lori
right?
Levinson would be a
As
good
the
person.
Innocence
Another person to
Project is
talk
way
to would be
behind.
Larry Doyle, who probably was the lobbyist.
The lobbyist thing.
Right, for this particular bill. But who was behind it? What was the energy behind it? What are they trying to do? I have a meeting of the LA County Bar's Professional Responsibility and Ethics Committee on Monday, and it has Kevin Moore as another person might be reasonable to ask, and I have a couple of prosecutors on there, and I can ask them that question. They're very active in legislation and lobbying and recommending legislation. That we could have somebody on that committee to give us a little insight
I think that'd be great.
as to what they're trying to do.
I think
So
that'd be totally
I
great.
can certainly ask around on Monday.
All right. Yeah, no, I don't think so. Yeah, no, I know, but is there someone else on the committee who wants to, join with
Sure,
Steve in the fact-finding
yeah, I
mission?
will.
Great.
But this is my third year. When was my third year up?
October.
October.
Well, or September. What?
So,
Yeah, by middle of September. I'll have a meeting in front of me. By the middle of September, your term will end.
is my last meeting in August then?
The vice chair, and if we have an August meeting, yeah.
Well,
It's probably sufficient.
There is a
for
meeting
this.
in
I think-
October, so if you were not appointed as vice chair, you would not be at that meeting.
Except as a member of the public and an honored emeritus.
you can still show up. This is
Yeah.
hard, this is hard to deal with.
So September 6th will be the last meeting involved.
You can come forever.
Yeah. I'll come as a member of the
Nobody will
public.
stop you.
Exactly.
Yeah, I'll be the first member of the public.
Well, that's,
Yeah.
that's what, yeah, that's what Suzanne said. She hasn't done it once. All right. Matt, you're assigned.
Sure.
Great. All right.
We
I
should
did
have a
not
more
understand
specific
any of this.
discussion. Who
Yeah.
else is it? Steve
And Andrew and Teresa.
we should have a
We should have a
more
call.
specific.
We should have a call next week and figure out who we'd like to talk to.
Likely, sure.
All right, guys. Let's talk about litigation funding, because I don't get some comments and help on this, I'm going to graduate from this committee without finishing it, which would be sad. It's been on my plate for a long time, and I just can't seem to make it work.
Why do you think it doesn't work? I think
I
it works
don't-
great.
All right, well, then maybe that's the problem, is I have some idea of what it's going to be that, anyway. Good.
I mean, you're right up you're right there. I mean, because it feels to me like you've dealt with in a very good way under California law with all the stuff that the ABA ethics opinion highlights as, I mean, the working paper, the Wendell working paper highlights, you've dealt with it very well.
Okay, well, I'm glad to hear that.
I was
Okay.
just thinking, why didn't you write a conclusion so we could vote it out?
I didn't even write a digest yet. I thought I did. I'm surprised. I feel like I must have not given you guys, I actually have a digest, so I will add a digest and a conclusion. But, so I did a couple substantive changes to this, which were, in scenario 1, which is the consumer financing, I suggest that the lawyer gets paid a little referral fee from the funder, but that there's no, that it's not, he doesn't have to disclose it because it didn't create a significant risk of material limitation. And so I don't know if people think that's right or think that's kooky. And the other thing I did thought I did. I can't really recall whether I did any other major changes. Yeah, so I guess there aren't a lot of major changes. I seem to have played around with it a bunch, but nothing major. So open to any feedback.
Well, I guess I'm on the subcommittee. So I'll start by just saying I think I did notice something that I thought was a typo, but maybe I misread. At line 253 of the red line,
Okay. Yeah.
while there are probably payments that are small enough to clearly not pose a risk, that the advice on whether to enter a funding agreement, I'm not sure that sentence quite reads right. Probably payments are small not to create a risk, the advice on whether in funding will be materially impaired.
Yeah, it's hard to read.
That's helpful.
It's actually 290.
Sorry, 290. While there are probably payments that are small enough to clearly not pose a risk, right? I would use one thing you want to say, there are probably payments that are small enough to clearly not pose a risk, right? That advice on whether to enter a funding agreement will be materially impaired.
Yeah, I can't even figure. It is a hard. Let's look at it in the clean. Yeah. He lost me too. My damn opinion. So it's scenario 1, right? Let's see. While there are probably payments that are small enough to take out that adverb, to not pose a risk, the advice on whether, that's a horrible sentence.
Yeah, I think I don't think you intended it quite to, I mean, I understand the idea.
The idea is that some
there
payments are so de minimis.
I would think you say there are probably payments that are small enough to not pose a risk, right?
Yeah.
That the advice on whether to enter a funding agreement will be materially impaired.
Right. Yes, you're right. It's the not that's the wrong. Will be impaired. Yeah. So the not at the end, Mimi, is.
But the there, it should also be while, because there's a sentence fragment if you start with while. So you need to take there are. And then it's a declarative sentence.
Yeah.
And I think it's
right.
I think it's probably right. That is to say, taking someone out to lunch does not create a disclosable conflict of interest.
Right. Right. Okay. Good.
And that's all I had.
Okay.
I mean, I basically think that
you're there.
It's just that you just
I have a comment.
Great.
Which I hope doesn't. Well, this is born out of like 2 recent client situations that have involved ethics advice related to attorneys who are getting litigation funding for matters. And I just, it made me think about whether or not that we would want to have that as a hypothetical, because I think it raises issues and it happens more often than we think. And I think all the analysis here related to disclosure duties and other obligations are in the opinion. But, for example, if an attorney who's handling, a massive representative action or a bigger case often gets approached by litigation funders or gets litigation funding related to, handling those matters, and to what duty do they have? Do they have a duty to disclose that information, the fact that they're getting funding to clients of theirs related to that action?
Wait a minute. The lawyer is getting funding?
Class action, you're thinking.
Yeah, like large class actions, whistleblower cases that are going to be, hugely involved and expensive and involve multiple firms. And smaller firms, for example, oftentimes smaller firms will affiliate with a lot of other attorneys to help defray costs, but sometimes these costs are insurmountable and they're tremendous. And a lot of litigation funders are approaching attorneys, not just about their clients getting litigation funding, but are approaching attorneys about helping to fund these cases.
Right.
And I think it raises similar questions about whether they do have an obligation to clients to let them know whether that would affect the client's decisions to use those attorneys, thinking that they don't necessarily have the resources, I think it raises questions related to disclosure of confidential information. What can the attorney disclose to, if anything, to these funders related to the matter without consent of client? I mean, it relates to the issues that are already raised in the opinion. So I'm not sure that it's, I hate to raise a new situation at the 11th hour, but I don't necessarily think the analysis, it's already in the opinion on those issues, but I think it's becoming more and more common. And like with the Northern District order relating to disclosures, I mean, I think that relates to disclosures regardless of whether it's the attorney that's getting the funding or whether
But it's only for class actions, I think.
the client, yeah, representative actions and class actions. I mean, I think it only, the situations where I've had it come up are related to larger matters, again, with firms that are trying to manage the costs associated with those. There's a lot of litigation funders out there that are very interested in putting their money in lots of different ventures.
Right, I mean, I just think, so if we are talking about class actions, where you don't actually have a relationship with a client, to me, that just, there's a lot of issues there about, I mean, I suppose you could make a disclosure to the representative.
Or like a quid tam action, or some other, like the whistleblower actions, or,
But here, is it an answer to your concern? I mean, the way this opinion is written, it focuses on funding arrangements with the client.
Right.
If we make it clear that the opinion is limited to funding arrangements with the client, right? And it's pretty clear that that's the way we framed it, right? Then maybe indicate that we're not talking about financing that is the law firm's obligations with respect to financing that it may receive. Because that does raise seemingly a whole bunch of different issues, like sharing of legal fees, right? Depending on how things are framed, right, and so forth and so on. That conflict of interest, obviously, right? And I'm sure my mind is running out of gas here, but I can think of a bunch of other issues that aren't raised in this hypothetical that would be raised in that situation. Yeah, including the situation of how on earth you get informed consent from the client.
There, in a different context, the arbitration advisories on fee disputes have covered the issue of fee dispute by the payer who's not the client. There might be something there. It's been 10 years since I've dealt with it.
Right.
I mean, there's portfolio funding, which is very interesting.
Yeah.
And I think actually right now is really the direction that this funding is going. Although I talked to some funders who said, no, there's still really a lot of this single client funding. But I just feel like that's probably like a different, could be just a different
yeah, I just wanted to raise it because I think it's coming. I mean, obviously there's a lot of funding out there. It's coming up, and whether we decide in a footnote, if we don't decide we want to include it in this opinion, that making it clear that there's a lot of other issues that someone should consider if there was an attorney that was seeking the funding on a portfolio basis or based on, a larger matter that, they were handling just for costs and things like that, there's questions they would have to consider, other ethical questions that are not being addressed in this opinion.
I mean, obviously they have to, if the attorney is getting funded, they have to do the, I know it's the 3310F disclosure, but whatever it is now, the disclosure that someone else is paying the fees, right? Which I don't know how you do in a class action, and I assume there's an answer to that, but.
Well, it would depend on what the funding was for. If it was just to cover costs, I mean, it just sort of depends on the way the funding is structured. And
well, funding would pretty much have to be. It'd be interesting. I think it'd be very tricky to have the funding be based on some kind of return of fees.
Yeah.
That would be super tricky, right?
Yeah.
Okay, so the options would be, I think about whether there's something that could be added substantively, or I drop a footnote saying this is just a separate issue that's not dealt with in this opinion. So that would be limited to funding arrangements with a client, not addressing separate issues arising where funding is flows to lawyer or portfolio funding. So those are two options. I'm happy to chat with you a little bit more about what your experiences are and think about whether there's some simple way
Okay.
of adding it.
Yeah, I mean, there obviously there's a wide range of ways in which people are proposing to fund matters, some of which raise a lot of problems and some of which are just more like loans and they're being characterized in a certain way and things like that. But I just know that that's happening more for attorneys and it's happening for clients and things. I mean, clients who are attorneys who are saying, how do we navigate this? We want to do this particular thing, so.
Okay, well, what do you think, Dina? Do you think it's something that could be added in a non-overhaul way?
Well, I think the fee sharing thing alone presents its own problems enough that
Right.
would make it so that you'd have to, make more of an overhaul. I don't know.
And there's this fascinating the New York City Bar Association came out with an opinion that it is fee sharing. I think any litigation funding, or was it this narrow one type?
No, I mean, I think it was a pretty broad brush, and a bunch of people, I think
taking
we
it
raised it in
back.
one of the recent meetings, and I guess we decided not to address,
Well, the
but
reason
a bunch of people have written about it. I mean, there's a lot of
there's a lot of writing, and
disagreement.
apparently they're going to take it back.
Oh, that I don't know.
Yeah.
They're gonna take
Rescind it.
it back, oh,
Yeah.
to
they're like-
rework it, or they're
yeah.
just withdrawing it?
Well, to
Who kno-
rework it,
yeah,
but I
okay.
think to come to a different conclusion.
Okay.
It doesn't say basically this enormous billion-dollar industry
Is
is unethical.
right.
Justin?
So I'm in the same camp as Steve. I think that this is really close, and I just had more, typographical comments. And I won't go through all of them, maybe just highlight a few, and then as we go through cleanup, exactly. So, for instance, we'll just need a capitalized lawyer and client, that sort of thing throughout. Consistently, I think also the other one to look out for is the gender of the lawyer. I think we just make it consistent. That sort of cleanup stuff we can talk about offline.
Sure.
And then, just really some of this cleanup, I mean, I can add just a few red lines later. I don't think I need to take everyone's time.
Just a couple sentences, though, that I think we need to refine. That's a little more substantive. Line 52 to 56.
In the green or red line?
In the red line.
Okay. 52, yeah.
I think where it starts over the course, I think it's one or two sentences.
Yeah, I see it.
It's missing a few words, so I think we need
Over
to
the course of
decide.
the litigation, funders and employees who have gained their former litigators communicate regularly with lawyer. There should be just a period.
Ah, okay.
Oh,
Okay, that makes a lot more sense. And then, as a matter of like facts, is it relevant that the funders' employees have JDs and are former litigators?
well, so the idea of what I was thinking about is how is the risk of interference with independence? And one is just that I do think funders they are all generally tend to be former litigators. And they therefore have an understanding of litigation that maybe the clients don't, and potentially are going to be more engaged with the attorney than the client. And I think a lawyer, I would have a concern that a lawyer tends to start thinking about the funder as the client, because they call them, they chit-chat about the judge, blah, blah, blah. So to me, it is relevant. I mean, it's not essential, but the idea, what I was trying to say is these people are going to have more of a close relationship with the lawyer as the case goes on, and you can tend to start thinking of them as the people you call, who are the client.
Right, well, maybe I understand what you're saying, that makes sense. And I don't have a particular place in mind, but maybe we add a sentence somewhere expressing that that's one of the concerns and tie it to the fact it's not already in there, which it might be because I read this week.
It's the very last paragraph. So it's the finally, and maybe it's not clear enough that I'm making this connection, and I can make it clearer. Finally, throughout the litigation, lawyer must not allow the relationship with the funder to impair the lawyer's objectivity. The fact pattern notes that the funder is in frequent contact with the lawyer, whereas the client is busy running its business. The lawyer must remain cognizant that the company is the funder, not the client.
Yeah, I mean, I still think that even connecting, if we're gonna have the facts as the funder's employees have JDs and are former litigators and are communicating with the lawyer, you might as well tie in that fact
Yeah.
to that portion of the opinions.
Sure.
And these are just little things I can push on later. Everything else I have is just a typo.
Great.
So
Okay, send me those, yeah. All right, if there's no one else who has comments on this, then we can turn to Marshall's if people have had a chance to read it. I don't think it was in our materials. It's okay, but it doesn't matter. Marshall, you can still describe like what's going on and, you know, see if we can make some use of the last half an hour to,
Sure.
even though I think everybody's a little fatigued.
Well, yeah, for about 2 months, nothing went on, other than some trials.
Yeah.
But what I attempted to do, and what you were handed this morning, is a different factual scenario than what was presented previously. And the reason for that is we received your comments 3 meetings ago, turned it around and tried to address those, and then had several conversations and decided that, one, simplify the facts, and two, try to take into account the kind of litigation Steve referred to as public interest law, but one where there would actually be kind of an open door to potential plaintiffs with the communication that you're coming in to see us on a confidential basis, to try to address how that might affect any of our ethical decisions. Because one, you have the open door policy, and two, it could affect a law firm's involvement in representing many, many parties on significant issues. So no real legal analysis has been added or subtracted, other than Steve did bring up COPRAC opinion 2003-161, which is added, that has caused me to think if we can agree generally the factual scenarios which need to be refined are an okay approach, the next step should be to actually do a draft analysis and opinion, which I could have done by June. The opinion, I think, would generally touch on conflict between confidentiality and loyalty, but as I expressed meetings ago, I think confidentiality always trumps loyalty. It's pretty simple. But a couple of the opinions we've talked about before, COPRAC has, do have some interesting discussions about ancillary interviews, ancillary discussions. When does a communication become confidential? And that's opinion 2003-161. That might be helpful. That one might be helpful to update it. Also, the opinion, I think, would be helpful if it addressed when does a duty to withdraw occur and the potential prejudice to many clients. Does the magnitude of the prejudice affect at all the decision to withdraw? So at this point, if people have an opportunity to read the facts, because they were handed to them this morning, and send me and Adam and Toby and Steve some suggestions, within the next couple of weeks, I would then try to refine the facts with our group and then launch into an opinion. I think it's at that point where we need to do that. So that's basically it.
Great. Okay, I personally, so I didn't get a chance to read this, and I'm excited to read it and give feedback. So I think so maybe we all just note in our calendars to try to do that for the subcommittee in the next couple weeks. That would be a good way of making it move forward.
One other thing I forgot to mention for my cryptic handwritten note is, I think after the new screening process, one of the things we can maybe help lawyers with is to understand how to prevent the problem.
Yes.
For example, just throw it out there. If you have a large public interest firm or a firm that handles large torts, key tam actions, whatever it is, if you have a screening process for interviewing clients that is screened off from the rest of the firm, can that help you? And obviously it can. So these are things we can discuss.
Yeah, I agree with that, and I feel as though we have an opportunity here, in part, the prospective client rule is brand new.
Yeah.
And one of the most interesting and difficult issues in it is screening. And when somebody who's been involved in talking to a prospective client can be screened, allowing the firm to proceed even adversely to that prospective client. And it's fair to say that there isn't a lot of, there's one, there's a sort of opinion that jumped the gun on 1.18, but there's a lot of interesting questions about what it takes to be able to screen in those circumstances. What the reasonable measures to prevent learning more information than is reasonably necessary to decide to represent the client. What the heck does that actually mean?
Yeah, we could really use an opinion on that.
That would be huge. And I think it fits right into your screening point.
I also would like everyone's input on whether they think scenario 2 is even necessary.
Okay.
When I reread it and was preparing to talk about it today, I thought, does it add enough to make it worth it? I think sometimes if you have too many scenarios and the facts are too complicated, you lose the thrust of what you're trying to accomplish. So I like to know if scenario 2 really needs to be there.
Would it be possible, Mimi, for you to send us all the group an email in a week with a reminder to review this and send comments to the subcommittee?
Sure. Well, how about I do that when I send out your assignments?
When is that usually?
In about a week or two.
Beautiful. Perfect. Perfect. Yeah, that'd be great. Cool. All right, so we have one more thing that we have to do, that I think we can get through without too much trouble, which is that 140003, which is page 39 in our materials.
Yeah, I was wondering about that.
Yeah, I totally forgot. This is an opinion that, did it go out for public comment and come back? I've just
Yes.
lost.
It was going to the board.
For final approval, right.
For approval.
And then we got a comment from one of the board members that Andrew thought, and I agree, was thoughtful and helpful, and so Andrew asked me to look at it, and so this is the opinion about a lawyer settling before withdrawing because the lawyer has discovered that the case lacks merit. There were two comments. One is just that a concern about the use of the phrase duty of honesty, and a suggestion that we make it duty of truthfulness, because that tracks the language in the rules and maybe is a little less broad. Duty of honesty might suggest a duty to disclose in the absence of a basis to do so that's not consistent with the way our rules work. So I think that is fine, and the red line is marked up accordingly. Then next on page 44 in caps, there's a suggestion about whether we should insert a sentence describing that what happens with the half-truth fraud. But I don't think, and I talked to Stephen and Drew, and they kind of agreed that we really need that because we actually have a quote from a state bar opinion making that exact point. So I kind of think that's not necessary. And then the most major thing suggested.
The language about the in violation of a duty to disclose, did you,
Oh,
just above there?
yeah. Right, okay, so this is the same point, it's in two places.
Right.
So the comment, this is by Sean Seleg, who's actually former COPRAC chair, and very knowledgeable in this area, is that he felt like the point that an obligation to disclose something to the other side before you settle only exists where something that you have done causes the other side to have a misconception of the nature of the case. And I think that, I remember that when we were drafting this, we talked about that and it was already in here, but I think the suggestions he has made brings it out more. So I don't think it changes anything about the nature of the opinion. I just think it's a matter of emphasis. So there would be two changes based on that. One is this addition of this phrase at the top in the first sentence on page 44. In negotiating the settlement, an attorney may not wrongfully conceal information material to the negotiations in violation of a duty to disclose. So that's a limiting on when I'm not necessarily sure that's necessary because I think wrongfully does that work. So I think we should either take out wrongfully and add the new words suggested, or we should just leave it as it is. But I think, you can't not wrongfully conceal information in violation of a duty to disclose. So there's a redundancy if we have them both in there. So does anyone have I like the change, and I think I would just suggest striking the word wrongfully.
I think that's more illuminating.
Yeah, exactly. And then there's another change I see in the middle paragraph towards the end. An attorney may be. Thus here, for example, if attorney's conclusion that the case lacks merit is based on information wrongfully concealed, attorney may be ethically prohibited from settling the case before withdrawing unless the misrepresentation or concealment is corrected. Oh, that's just a change in. That's weird.
No, I think it makes sense.
Isn't it the same? Doesn't it?
No, because it could be corrected by the client.
Oh, okay.
Right? Or it could be corrected due to some external circumstance so that the lawyer believes it's no longer misleading in the circumstances because it's come out in some other way. So it's not all on the lawyer.
Right.
Although it could be on the lawyer.
Fair enough.
Most likely.
Yeah.
Do you guys have the comment? I may have an older version, but his comment says, I made these changes to allow for the possibility that the client and not the attorney.
Sorry, the comment that accompanied the original edits said, I made these changes to allow for the possibility that the client and not the attorney violated the discovery obligation.
Right. Okay, and then the last, there's more than, the big additional paragraph, basically, as I said, brings out this concept that the lawyer may be able to negotiate a settlement without sorry, I'm reading. The other hand is here. All right, so this is the situation where the information that causes the lawyer to conclude the case is meritless is not known to the other side, but that's because not due to anything that anyone wrongfully concealed. Then the lawyer, this edition is suggesting, could negotiate a settlement as long as statements are truthful and don't violate a duty to disclose. And then the last sentence is the one there's a little, I think So the last sentence says that the lawyer needs to consider in that situation whether they've done anything that could be considered false or misleading. What I would suggest is taking out the parentheticals, such as allegations in the complaint, because I don't like the implication that allegations in the complaint are something that the other side can properly rely on. I mean, I don't know any lawyer who's worth his salt who takes allegations in a complaint as facts they should accept.
Even if they're verified.
Yeah. Okay, and I guess let's talk about the last one. You're right, I don't have the comments, so I see that Sean did make a comment also in the paragraph, that's the last paragraph of the main opinion, under our facts. What's that?
Access?
Yeah, what does that comment say?
Yeah, it says,
It says, this suggested change is related to the additional paragraph to consider above. It is not uncommon that an attorney might have or know of unfavorable information that the other side could discover if it were diligent. It seems overbroad to me to suggest that mere opportunity to obtain the information would be sufficient without considering the overall context, such as the allegations of a pending, he says appending, I think he means a pending complaint that could be called into question by the new evidence.
This sounds like something he's thought about a fair amount. I wonder what he's
He
thinking.
probably had a case where this happened.
I wouldn't have said, I just wouldn't, I think the challenge in some ways in this sentence is that it feels to me like statements is too narrow, right, in some odd way, and suggesting that the pleadings would trigger it necessarily, so maybe overbroad.
So we could certainly add statements or conduct to that.
Okay, how would conduct do it, though? Now let's think about that. That's what I'm a little wary with that, because I that was my instinct too. But then I thought, what's the conduct that would get you in trouble for doing something that's deceptive? Indicating.
I like it the way it is. I was immediately thinking of defense lawyers had a sub rosa on the plaintiff's victim, and the sub rosa shows this victim's out playing soccer and claims to be paralyzed. Plaintiff's lawyer doesn't know it. Defense lawyer settles the case anyway for a nominal amount. Now, maybe that's not a great example, but there's all kinds of private ways defense counsel or plaintiff's counsel could learn stuff that's either helpful or hurtful to their case. If a duty to disclose information starts existing between adversaries, the adversarial process gets kind of compromised. I think in normal fiduciary relationships, if you don't have a duty, I mean, only in a fiduciary relationship do you have a duty to speak. So why create a potential duty here?
I think the question is, for me, Marshall, is what about the statement in the sentence? If suppose you're the plaintiff's lawyer, what kind of statement, what kind of allegation in a complaint would you regard as creating a duty to disclose under half-truth? That's really the issue. Right?
Yeah.
Suppose let's flip the case around, right? You discover that your client has been withholding some critical piece of information from you.
Yeah.
Right? And that critical piece of information shows that you've alleged something in the complaint, causation, who knows what it is, right? But you've alleged something that is just not true.
Mm-hmm.
Can you now settle a case? Is the allegation in the complaint something that gives rise to half-truth liability that you have to correct or not? That's the question, because the implication of this addition is that if you've alleged it in the complaint, you can't settle a case without disclosing the information.
Yeah, I don't think that's right.
So you've alleged in the complaint, and the basis of your conclusion is there's a presumption it was a good faith allegation? That you
Or
had some
something
factual
like
basis?
that. You have
Some
some
factual-
evidentiary basis for it, and now you have none. I'd take it out. I mean, I would take that
Just the
language out.
parenthetical?
What? The parenthetical.
Is that what you're saying? Yeah.
Yeah, I'd take the parenthetical out, not because it might not be true. It might be true in some circumstances, maybe if your allegation is sufficiently detailed, right, as to suggest that you actually have more, the more detailed it is, right?
Yeah.
The more specific it is, the more likely it would trigger that, but I don't think I'd want to get into the general view that any allegation triggers that.
Right.
Yeah, so, okay, so are we okay if we take out the parenthetical? And are you still concerned, Steve, that it doesn't have to be, that we're
I don't
limiting
think
it to
it has to be
statements?
I don't think it has to be perfect.
Yeah, okay. All right, and then I think I'm okay with his other suggested change, which is just changing in the sentence in the last paragraph to say, attorney concluded that the client's case lacks merit through the discovery process, suggesting that both sides had an equal access to the information attorney possesses. Oh, well, I don't know. I mean, the way we had it before is opportunity, so that, and I kind of like that better. Because if someone dropped the ball, I don't know why actually Sean's suggesting this. Well, maybe he's trying to capture the same idea. Like, we don't want a lawyer who does a crappy job in discovery. That's just not our problem, right?
Right.
And so which is the phrasing which captures this better? Both sides had an equal opportunity to learn the information. To me, that says if you'd done your good discovery, you would know this. Or is it better to say each side had equal access to the information? That's not ever going to be true. One side always has better access to their client's information.
Well, they also, there's not an equal opportunity because if you have it, I mean, there is an opportunity for the other person to get it, but it's not equal.
How about a fair opportunity? Isn't what we
Fair.
really want to
Yes,
say is
equal's
a
the wrong
fair
word.
opportunity?
Yeah, that's good.
Are you saying maybe the attorney didn't do anything to prevent access to the information?
Yeah, or
that's the
anything
same thing.
unethical. It's
Right.
fair opportunity. So you might have made a proper objection to non-frivolous objection to discovery, which actually would probably be overruled,
Right.
but it might still be a legitimate basis for resisting discovery. I would say and they choose not to press the objection, right?
Yep.
That's a fair opportunity. It's not necessarily equal.
Yeah.
It's fair.
Can you make
That's
that
the
change
that's
there?
putting the
I
adversarial
know, it's
idea
okay.
that Marshall
It's
talks
okay.
about.
So we're going
What?
You could delay a deposition.
Yeah, you could say postpone a deposition because you've discovered that your client is, once they have to testify, they'll have to say something.
fair
You learn your
opportunity
client's
is the way we
line
want to go with this.
before you can be deposed, you settle.
We're
Never
we're
happened.
taking equal out, we're changing it to fair. And then we're rejecting Sean's proposal. Yeah. Good. Yeah. Yeah, the opportunity to learn. Yeah, learn, yeah, thank you. Yeah. Okay. So this one now can go back to the board, yes? Do we have to redo it?
I think it's gotta go for.
Oh, Andrew, not really. There's
It's
nothing
not- this
substantive
is-
here at all. We've just clarified the reasoning of the opinion. It doesn't change anything substantively.
I'm just worried about on the other hand.
It's the same concept. This was always in here.
Okay, I'll have someone look at
Okay.
it.
Get a second opinion.
Actually, I have I hope these are not objectionable. On page 2, listed point number 2, the lawyer knows, I think the rule says, or reasonably should know.
Where are we? I'm sorry.
On page 2,
Yeah.
withdrawal is mandatory, listed point.
Oh, I
number
see.
2.
Lawyer knows or reasonably should know that the action is being, what's,
I just want to add the word reasonably in front of should.
It says it's here. Oh, in two.
Oh.
1.6, in
Or
A2.
reasonably should know. Yes, yes.
Non-substantive
Yeah.
change would not need to go up for public comment. And if I just add to this, I don't feel strongly about this, but again, looking at the rule, reasonably foreseen prejudice to the client, which I know is what we say colloquially, the rule says to the rights of the client. I don't feel strongly just raising in case anyone else feels inclined to add the phrase to the rights of.
I actually like that.
Yeah,
I think that's
I think
better.
we should add it.
Yeah.
Thanks, I'll shut up now.
Great. So what do we need to move for?
To approve the opinion again, and then we have to make that motion, vote on it, and then we can say, we have to have OTC review it to see if it does need to go out for public comment. But we could just approve the opinion.
I'm sorry, how did we end up on that last, on the other hand paragraph? Are we taking out that last sentence, or parenthetical? I didn't.
Just a parenthetical was.
Yeah, we just took the parenthetical out. Are you okay with the new sentence or no? Do you want a day to think about it? Well,
No, I can't meet tomorrow.
yeah. We can't? Huh. All right.
You got notice of 10 days in advance. Bag the key, baby.
Back the key.
Back to Keen, baby.
All right.
Immediate autocorrect to the wrong right.
So,
Right. The wrong rights.
Well, I put a.
Yeah, I see it.
okay.
Okay, so is there a motion? To approve
I
this
move
opinion?
to approve on the terms described by Mimi.
Second.
All right.
All right. Okay, we have to vote on it.
Yep.
Amy Bonzi.
Yes.
Stephen Mundy.
Yes.
Kendra Basner. David Carr. Eric Dietz. Justin Fields.
Yeah.
Matt Hodell. Toby Inlander. Adam Koss. Amber Lee. Dina Roche.
Yes.
That's
Teresa Schmidt.
That's what we would do. and I-
Richard
I-
Solomon.
I-
Stephen
how
Sparta.
many
Marshall
people are
Whitney.
there?
Yes.
Me and
Thank
who
you.
else?
Drew and Dina.
Oh, great. So I'll call.
Tell everybody which ones will be discussed.
Yeah, okay. Yeah, no, this was a great meeting. This was a super meeting. So, two things. Anyone who wants to come to dinner tonight with me and Steve, what's the
And
address?
we won't be hurt if you don't come
I will.
very much.
I will. I'll drink all the margaritas. What's the address?
It's 445 South Figueroa. It's right across the street from the hotel, I
Okay.
believe.
At 6:30.
6:30.
Be there at 6.
Excellent. Seriously, are you going to come?
Yes.
Okay, good.
Great.
So, and Dina, do you think you can come?
I think I am gonna come.
Great. And Drew's
Good deal.
coming, so there's 5 of us so far. So get rid of one of the tables,
Yeah, I'll get
right?
rid of one table.
Well, and
Yeah.
some of my panel asked about meeting up, so I don't know.
Bring them.
Yeah, I think she's not flying in until 6:45 or something, but I might just say that's what we'll be in.
Totally.
Yeah,
Yeah, the
absolutely.
more the merrier.
That's great.
And then